Late Prince Lordship. Whether I am mentioning item number 21 of the hearing list. This was a part heard matter before in court number 19, which was heard extensively. And today it was fixed for final consideration. Wrongly, it has been restricted.
Court number 19, who is the presiding judge?
Honorable Justice Devashish Bora.
Sorry?
Devashish Bora.
Item 21, you write 21, 22, 23, all three matters. Mr. D.K. Das, learned counsel for the petitioner, submits that these matters have been extensively heard by another bench of this court and had been kept part heard for further hearing today.
Yes.
Therefore, these writ petitions have been wrongly listed before this court. First up, on the Mr. H. Aliya, learned, anybody is there for the respondent?
APSC.
APSC. Register to verify and list this matter before the appropriate bench. Yes.
But I beg to mention item 6 of today's list, my lord. Here, the finance department asked to procure certain OMs, my lordship. I have informed the other side we need 2 weeks time, lordship. Yes, lordship, we have informed the other side, lordship. 2 weeks time may be granted, my lord, so that we can procure the necessary OMs, my lord.
All right. With the consent of learned counsel for the writ petitioner, Shri H. Aliya, learned standing counsel, Finance Department, Assam, seeks to further time to obtain instruction as called for. First up, since the prayer is made with the consent of the other side, same stands allowed. Let this writ petition be listed accordingly. Yes.
I beg to mention, your lordship, a writ petition being filed by certain officials of SSB, your lordship, against the impugned order of impugned OM dated 23/9/2022, passed by
What do you want? What do you want?
lordship, listing by tomorrow, your lordship, considering the
Is the
urgency.
motion matter?
Motion, lordship,
Motion, first listing.
first listing, lordship,
Yes,
considering.
yes, yes. You have quite a few mentioned memos. You are
Yes,
mentioning
yes.
only one matter,
Just one matter.
only one.
Only one.
Yes, you please give it.
Obliged.
Will come tomorrow. Yes.
May I please, Your Lordship? I beg to mention for listing for motion matter. Lordship. He is a SSB employee, Lordship, and he is dismissed from his service, Lordship. Any day
Monday.
of this.
May it please your lordship. Lordship, I beg to mention 2 analogous WPC. Lordship, for admission, any day on next week, lordship,
No, you put a date for week commencing from 27th February.
on 27th of February.
Yes.
And
Put the date
27th
of
of February,
1st March. Yes. 1st of March.
1st of March.
Yes.
Obligation.
May you please, Lordship, I'd like to mention for the listing of contempt case
Hmm.
of orders.
Contempt case. What is the urgency?
I think this order will pass with to the parties with for the job.
You want quick contempt, somebody to be put to jail or something like that?
No, not the
All right. When do you want it?
next week, any day.
Next week, not possible. You put 1st of March.
Okay, obliged. Really, this promotion item one.
May it please, Your Lordship.
Yes, just a minute. So your purpose is solved?
Lordship, today they have given an order.
Yes, they have given you, assigned you duties.
My lord, the last paragraph is the specific, my lord, order. My lord.
Lordship, I may be given a week's time to take instruction because
No, we'll close it. What week's time?
Lordship, till now they have not, they're in home only. Lordship, today I got this order.
My lord,
Yes,
this was
this is the
passed.
order, yesterday's order.
Yesterday's order, my lord. Copy is marked to them, my lord. They will get it, my lord, today.
Till now they have not received any order.
My lord,
In the morning only I have talked with him.
these,
They are in their home.
All right, you obtain instruction. These are orders of government. We'll record it in the court order.
my
What
lord,
else
this
do
is
you
the
want?
part of the record, my lord.
Lordship,
You examine the order. We'll take it after 10 minutes. Mr. Mohanta, for asking, will not keep posting matters like this.
No, Lordship,
It is disturbing our way of functioning.
the only
The
thing is,
government has accepted the suggestion of the court, given you posting. You
And
ask
all,
them,
all in Guwahati, my lord.
everybody is in Guwahati, this will not alter your service conditions.
Everything, my lord.
Yes, after 15 minutes, you take instruction.
And I have served a copy also to him, my lord.
Yes, yes. No, he is entitled to
Yes, my lord.
consult his
And,
client.
and these copies are marked to the petitioners, my lord. They will
All
get
right,
it.
we'll incorporate it in our order.
Exactly, my lord.
So what else is there? Yes,
My lord, I have received the instruction that my lord, the petitioner, my lord. He is appointed by the hospital.
no, please first answer the queries raised in the order dated 10/2/2020.
Yes, my lord. No
After
notice-
that, we'll go to other.
Yes, no notice was issued, my lord.
Then we'll set aside the order. You cannot do that.
But my lord, otherwise.
Even if he's stolen something, you can't do that.
No, my lord, he is not appointed by the government, neither he has been terminated by the government.
Hmm,
It is the Hospital Management Society, my lord,
hmm.
who has appointed the petitioner and subsequently they have terminated their service. That
Where
is
is the order of termination?
order of termination, my lord.
page
at
18, my
page 18, my lord. It is, my lord, office of the Hospital Management Society.
This order is passed by superintendent of,
Yes, my lord, he is the member secretary of the Hospital Management Society. Appointment letter was also issued by him, so superintendent come, member secretary.
so
of
it
the
is not a private body.
Hospital Management Society is a private body, my
How
lord.
can a superintendent be the member secretary of a private body? You know what you're saying?
Yes, my lord, because the ex officio member of the Hospital Management Society, that is a registered, duly registered society.
Hmm.
And the person being the superintendent, he is the ex officio member secretary of the society, my lord.
So they can be terminated without issuing any notice.
My lord, if he has any grievance, my lord, he can approach appropriate forum, my lord. But because, my lord, the writ petition is not maintainable, because neither that is my lord, government, neither he has been appointed by the government, nor he has been terminated by the government, my lord.
Hmm. And why have you terminated without a notice?
My lord, there was a FIR, there was a inquiry done, my lord. So your lordship may peruse it, because there was
We'll
a,
peruse it, but can you please tell us what
Yes,
is
my
it
lord.
even?
because a copy of the FIR he has enclosed, my lord petitioner, there was a racket going on, who was collecting money
Hmm.
for supplying blood, my lord, to the patient, my lord. 8,000 to 9,000 rupees was collected for supplying blood illegally to the patient, my lord.
Hmm.
So accordingly, a person was caught red-handed. He was
Hmm.
apprehended by the police. So thereafter, my lord, he revealed the name of the petitioners and some others. Thereafter, inquiry was done by the hospital authority, wherein, my lord, they were found to be guilty, and therefore, my lord, they have stated your service is not required, my lord. Because in a blood bank,
This
my
is a very debatable issue, but yes, Mr. Deka, what you have to say?
My lord, at page 18, my lord,
Hmm.
this is the impugn order.
Yes, I have seen.
My
it.
lord, I have been, my lord, discharged from service due to flouting of government rules and regulations, my lord. If I am not a government employee, my lord.
That's right. So, Mr. Deka, the point is, we'll give them just 2 weeks' time to file affidavit. And the matter will be taken up for disposal at the admission stage. Beyond that, nothing can be done.
Yes, my lord.
Only 2 weeks. Otherwise, we'll go ahead with the matter as per the materials on record.
Yes.
So the matter will be posted after 3 weeks and we'll take it up for disposal.
Right.
Heard Mr. R.M. Dekal and counsel appearing for the writ petitioner. Also heard Mr. B.P. Bora, Learned Standing Council, Health and Family Welfare Department, Assam, who has obtained instruction as per the order dated 10/2/2023 and submits that although no prior notice was issued to the petitioner before discharging him from service, yet, Mr. Bora submits that there are serious allegations of malpractices and flouting of government rules by the petitioner. On the plea of non-compliance of principles of natural justice, it is the submission of the learned departmental council that the petitioner was never in government service, but was an employee of the
Hospital Management.
Hospital Management Society
On
of the
contractual,
Guwahati Medical College Hospital
on contractual basis.
on contractual basis. Therefore, the principles of Article 311 of the Constitution of India, according to Mr. Bora, will not be applicable in this case. Mr. Deka has, however, refuted such contention of the learned departmental council. Full stop. Be that as it may, the issues raised during the course of proceeding today would call for deeper consideration by this court. Full stop. In view of the above issue, however, since the petitioner has already been discharged from service, there is urgency in the matter. Full stop. In view of the above, issue notice of motion returnable on 10/3/2023. Since Mr. Bora has appeared and accepted notice on behalf of all the respondents, no formal notice is required to be sent in this case. Extra copies of the writ petition, requisite in numbers, be furnished to the learned departmental council so as to enable him to obtain instruction and file affidavit. The affidavit on behalf of the respondents would be positively brought on record on or before 3rd March 2023 by serving advance copy upon the petitioner's counsel. Full stop. The petitioner may file rejoinder affidavit thereafter, if so advised. Full stop. This matter will be taken up for disposal at the stage of admission hearing. Registered to list this case on 10/3/2023 as a fixed item, along with WPC number next matter to. Tata same order.
3 and 4, 2, 3 and 4.
Next sequence. Tata same order deploy, it will never be scored.
I oblige you.
Oblige, madam.
And for the respondent workmen
Hmm.
against an award passed by the Labour Court. Okay,
Yes.
it is their writ petition and
Whose writ petition?
by the management. And
You are for the management.
Yes, ma'am.
He is always for the management.
Yes.
Yeah. Yes. And the same is true for you also. You are
No, sometimes management also.
Actually, you also switch, okay. So is it a matter which can be
Yes,
disposed of?
last time Lordship expressed that Lordship will be taken up, this matter will be taken
All right,
up.
all right, all right. We'll hear it.
This is against an award
Hmm.
by Labour Court. Now,
What is the date of the award?
the date of award is 11th March 2020. The workman was an employee under the hospital,
And which page is the award?
113.
All right. Hmm.
Hospital, she was an employee under the management hospital. And there was an incident in the year 2017 where she was charged of committing some misconduct. But she was let off by giving a warning, and she was advised to mend her ways. But things did not improve 2018 onwards, from the end of 2017 and 18, she started sending voice messages, threatening messages, calls to the superiors and the HR head. The matter went to a pass that she also started instigating some staff in the hospital in creating dharna and etc. Then an order of suspension was issued.
Hmm.
Page 30 is the order of suspension.
Page 30.
229. Page 29 is the order of suspension.
Do you think it's time for AC?
No.
No.
29 is the order of suspension.
Hmm.
Miss So-and-so, Junior Assistant, Hospital of Nursing is hereby put under suspension with immediate effect. During suspension, Miss Kakumani Bhuiya will be allowed subsistence allowance. inquiry and formal disciplinary proceedings in progress. This was followed by the next
Yes.
communication, which is at page 30. Page 30 is dated 25th of April 2018.
Hmm.
You were found sending intimidating, threatening voice message and pictures to the HR head in the months of December 2017 and April 2018. You are therefore put on suspension for breaching clause number 2122 of the standing order. You are advised to give suitable explanation within 48 hours of receipt of this notice. In case we do not receive suitable explanation from you within next 48 hours of receipt of this notice, the organization will take appropriate disciplinary actions against you. Thereafter, she submitted an explanation which is at page 31, where she virtually admitted the allegation. With due honor, I want to state that I have received a notice number so-and-so in which it is written about my suspension and a suitable explanation is asked for me regarding the same. I want to assure you that I do not have any intention to bring down your reputation. The photo which I had sent to you was found in social media. I thought that if the people of Assam come to know about these things happening, then the reputation of hospital will be hampered and it will suffer irreparable loss. Being an alert employee of the hospital, I never expect this to happen. Even in the past, I had discussions with the human resource manager regarding the same, but I got no favorable response from him. Pictures I have been sending you since 2017 were to completely protect the image of hospital and also to safeguard the interest of the patient. Again, when I saw a word girl from our hospital performing an ECG in social media, I tried to meet you in person in order to make you aware of whatsoever going on inside the hospital. But unfortunately, not a single chance was given to me. Being helpless, I sent a voice message to you in order to safeguard the reputation of the hospital. Another reason for sending the voice message was because I knew that you do not know how to read Assamese. And if for these reasons you all have found me guilty, I am not aware about the same. Thereafter, the next page, your lordship will find the reply in vernacular. This is the translated version, page 32 and 33. Thereafter, on 5th of May, page 34, communication was sent to her. With reference to the subject cited above, we would like to inform you that the management of Apollo Hospitals has decided to conduct an inquiry of the charges brought against you by this office letter number so-and-so dated 20. Your lordship may kindly mark this sentence. 25th April 2018, as the management is not satisfied by the response provided by you. For the purpose of free and fair inquiry and to abide by the law of natural justice, the management of Apollo Hospitals has decided to appoint Mr. So-and-so as an independent inquiry officer and so-and-so as presenting officer. The date of inquiry will be notified by the inquiry officer separately. During inquiry, you will be given the opportunity to cross-examine the witnesses, examine the relevant documents or produce the witness if any. If you want to take assistance of your co-worker, you can do so by applying to the management in advance so that she can be released during the course of inquiry. Now thereafter.
Okay, just a minute. So an inquiry proceeding has been initiated.
Yes.
To inquire into the charge.
Yes.
Where is the charge?
Now, the understanding of the management was that the previous letter dated 25th of April, which I have read out to your lordship, that is the charge. But
don't you think it was a wrong understanding? Mr. Datta?
My lord, in a sense, my lord, yes, the heading of the letter is something. The heading says
forget the heading.
Suspension.
Forget the heading.
Right.
Let's go to the other part of the letter. Where is the charge?
The charge is clear that
You have done something wrong. That's the charge.
No, that she has violated clause 20.1.22 of the standing order. That is the charge.
What is the imputation? Where's
Now,
the imputation?
the imputation is that sending intimidating and threatening messages. Of course, I admit, my lord, that it needed to be elaborately said. But for the fact that all these allegations, the incidents are of 2017-18, and there are multiple incidents when she had sent messages and
So what
all
has
that.
happened? She has been dismissed.
yes, she was terminated thereafter, after the inquiries. Now, I understand, my lord, had it been a case that she had not admitted to the sending of the messages, or she had taken some other plea, the things could have been different. But whatever has been stated in this 25th April letter,
She has admitted, but she has projected a different version. You
Yes.
can't take half of it and then take your own.
now,
She said, I forwarded to you because I wanted to protect the reputation of the hospital. Because you will not understand Assamese, therefore I have sent you the voice
no, the
message.
other incidents, I'll take your lordship to the other incidents that she committed in the hospital, my lord. For which, my lord,
Mr. Datta, you are a very seasoned lawyer, particularly superbly trained in service matters. Why are you arguing things which you know the court is never going to appreciate? It is a case of termination from service. You initiate an inquiry against an employee. You don't tell her what is the charge. Some circulation of messages, and there is a version given by her that this is what she did. If that version is accepted on face record, there is no misconduct here. Then, all right, you may or may not agree. You are entitled to, impose disciplinary measures on an employee. That obviously the court recognizes. But the fact remains that we are a country governed by the rule of law, and it has to be followed. It is
Now-
equally true for the employee and the management. So what is
Well-
the court supposed to do? Tell me.
my lord, this, I admit, my lord, this is a defect.
Why don't you advise your clients?
This is a defect. But my humble submission before your
You want the
lordship,
court to write a judgment in this? I mean, Mr. Datta will hear you. There's no difficulty. We'll hear
no,
you. but-
only two counts the tribunal has
But we
got.
can hit the nail in the head in 5 minutes, then why should we wait for 45 minutes for doing it?
No,
Is it
subject-
not the crux of the matter?
Yes, yes.
Then
Subject to what my friend will say,
Hmm.
my lord, I
take her
think
back, serve a charge memo, initiate a fresh proceeding.
that, yes, that.
But
that
take
is
her
the-
back with whatever benefits she is entitled to.
That will follow, that as the law provides, my lord, that will follow.
If you want to, seek instruction from
And
your
she-
client, that also. we
And
are-
she is already getting she is already getting protected under section 17B. So,
17B.
yes.
She is getting 17B
Yes,
protection.
So she is getting,
Take her back. Serve a proper notice if you want to proceed against her. Let her a reply. After that, if the management feels she should not be kept in the, that is absolutely okay. We can't say anything on that.
actually, that is what I would have submitted, that this is the course what the tribunal ought to have taken.
That's so, we could have come to this point after 1 hour. But unfortunately, this court operates like this. So in 2
Yes.
minutes, if we have a consensus, then we'll finish it off. What do you have to say, Mr.?
My lord, if my friend.
We are
has
setting aside the order
Yes,
and
my lord.
they are
lord, so
taking
for-
your client back. What do you have to submit?
My lord, so for initiation of a fresh proceeding, my lord,
Ah,
this is an award.
hmm.
Award, the Lanet Labor Court has examined everything.
Yes, it is in the context of the memo served to her earlier.
Yes, I'll come to that, my lord. Lanet Court has examined and is held that you have not examined any witness. You have not given him any show cause. In fact, this is not a show cause, rightly pointed out. So a fresh proceeding at this stage, because no charge is given.
Take up that plea when the fresh proceeding comes. You never know, they may not. We
My
are
lord,
not
if that
asking them to
liber- my
initiate a
lord,
fresh.
If that liberty is given,
Liberty will be given.
if that,
That the court cannot prevent the management. It is not our institution.
my lord,
The management is the master of the institution. How can the court restrain the management?
that is,
Whether you convince them, if they do something which is impermissible in law, we'll examine it.
now,
But we can't restrain the management by saying that this is bad and in future also you can't do.
No,
How
my
can
lord,
that
I'm not
order be
on that.
passed?
I'm just on a different issue, my lord. They had initiated a disciplinary proceeding.
Yes.
The charge sheet was vague.
Hmm.
They concluded and then imposed the punishment. Under the Industrial Disputes Act, we raised the dispute and the matter went to the Labor Court.
Correct.
Labor Court found that the action was because the issue was whether the management was justified in terminating.
Hmm.
And the Labor Court held that management was not justified in terminating, an award was passed,
Hmm.
reinstating me back in service.
Yes.
Now,
Why it was not justified?
because they could not prove the charge in the
There
Labor
is-
Court
there
also.
is no charge.
There is no charge, even the MMS and the SMS were placed before the Labor Court and the Labor Court held that these are not certified, duly certified, you cannot act upon it. So ultimately on merit also, labor court.
So
had-
we'll say permissible in the eye of law, they will be at liberty to initiate further action in accordance with law. If they do it, you raise that plea that it is not permissible in accordance with law.
And after the award
That
was,
order, Mr.
Lord.
Chakraborty, will be very difficult. Because you see, we don't want to encroach in the authoritative field of the management. This is not the job of the court.
yes, my lord.
The court will not, see, imagine you are the head of an institution. It is your business to maintain it, to run it, right? You may or may not be happy with the conduct of an inquiry, of an employee. And the law gives you the liberty to proceed.
Yes.
The courts come in only when the rights of the citizens or the employees are violated, nothing more than that. So once we find that the procedure was bad, can we say that this is bad and for all times to come you can
No.
proceed?
Had it been a writ petition directly against the government action, then my lord, things are different. Your lordship is examining the under 226, your lordship is examining whether the labor court was right in passing that award. If that is the reason, then perhaps to go further in giving liberty, in my respectful submission, lordship may not like to do that. Because,
Then let us read the award.
yes, my lord. And their plea, my lord,
Hmm.
is that they were not given the opportunity to adduce additional evidence. That is the only plea set in the writ petition.
Hmm.
Now, law is very settled. You have the right to examine the validity of the inquiry in the labor court. And if you want to adduce additional evidence, then you have to take that plea in the written statement itself. It is only when you take that plea, you get the additional advantage of proving the charge in the labor court
No,
directly.
but additional evidence happens after the evidence is adduced.
No.
So how
There
can
is-
someone take that?
My
plea?
lord, there is a difference in the, under the Industrial Disputes Act.
Hmm.
Person is dismissed pursuant to an inquiry. So management has two options. One, they will say that I rely on the inquiry. And when the inquiry is held to be bad, then management has no other option. Award will be passed, directing appropriate action, that reinstatement. But management has a second option, that yes, if the inquiry is held to be unfair, then management will be given the liberty to adduce evidence on the charges in the directly before the labor court. So the role of the inquiry officer is taken up by the labor court. However, if you want to take that plea, you have to take it in the written statement when you file it. And after that, you don't have that chance.
Is there an authority
Yeah.
for it?
My lord, is a constitutional bench judgment, my lord. Somunath Goel's case first, then two different judgments were there, and ultimately the law laid down in Somunath Goel's case. I've given the list of books, my lord may take up that. So, my lord, there are two things. In Ludbud Singh's case, the management was given the liberty to rely on the inquiry and then proceed simultaneously on the charge directly. That is called evidence on merit. If that is done, then after the inquiry is held to be bad, the court considers the evidence that is adduced before the labor court and then passes an award. Here, my lord, they have not taken that plea. So, once the inquiry is held to be bad, they don't have any other option. Even they cannot bring evidence in the labor court. Here in this case, they have not even examined the inquiry officer. If your lordship goes to the inquiry, my lord, who are the witnesses examined is not there. The inquiry officer says that I admit the charge, and lordship has seen my reply. It says that this is what I got in social media and I have forwarded it to you. And I have forwarded it to you because I want that the interest of the institution to be protected. So inquiry officer takes it as an admission on my part and finds me guilty of the charge. And in the labor court, my lord, they have decided not to even examine the inquiry officer, not the inquiry process records of inquiry. And there is no, my lord, pleading that they would like to adduce evidence on merit. Lordship, I will sending this, I'm giving the judgment, man.
Hello, may I just, before he places the judgment, on the judgments, my lord, there is no dispute. I am not disputing any of the propositions. One sentence is apparent in the judgment of the learned tribunal. So far as the question of not relying on the inquiry report, he also says, and this is the position of law, that if I do not wish to rely on the inquiry report, then this opportunity of additional evidence is open to me. In the judgment of the lower court, tribunal, my lord, your lordship will find at page 117.
Acha, then let us do one thing. Let us just go through the award.
Yes.
Then Mr. Chakraborty, then
Yes,
in
ma'am.
the meantime, you give him the list of, give us a list of books. Yes, let us go through the award. Is it a very long one?
Page 113.
113. Okay.
The Lordship can start from page,
83 4 SCC 491.
Lordship can start from page 114.
2001 5 SCC 4.
She has rendered her service sincerely to the hospital, acquired knowledge and skill through training in various fields of the hospital, and for that certificates are being issued to the work lady by the competent authorities of the hospital. And being satisfied with her service, the management upgraded her to junior assistant. It is also averred that she being a senior employee sometimes had played the role of spokesperson for the employees before the management, highlighting grievances of the employees regarding the service conditions for which she was transferred to a separate unit. Thereafter, on 24/4/2018, the chief executive officer issued suspension of the work lady with immediate effect, and in the said order, it was indicated about inquiry and formal disciplinary proceeding. Thereafter, on 25/4/2018, the chief executive officer of the management put the work lady under suspension of the allegation that she was found intimidating, threatening through voice messages and pictures to the HR in the month of 2017 December and April 2018, and she was asked to submit explanation within 48 hours of the receipt of this letter. The management did not get satisfied and decided to conduct inquiry, deciding further to appoint so-and-so as inquiry officer and so-and-so's presenting officer, further intimating that the date of inquiry will be notified by the inquiry officer separately. That in absence of charge sheet, appointment, inquiry officer, and presenting officer, the management's chief executive officer asked the work lady to be present for hearing before the inquiry committee. In response, the work lady, engaging her legal activist for her defense, asked the management for permission, but that was denied, for which the work lady could not attend before the inquiry committee. The management did not issue any charge sheet, and without adhering the principles of natural justice and laws of the land, the chief executive officer by letter number so-and-so dated so-and-so terminated the service of the work lady. But after receipt of the termination letter, the work lady submitted representation to the management, but went in vain, hence the prayer. In the written objection, the management stated that the provisions of the industrial and labor law for the welfare of its employee are being followed. The management also admitted that she was employed in the year 1999 as work girl, and on her performance and experience, she was promoted to junior assistant in the year 2009. But according to the management, the work lady had the habit of interfering by instigating the employees against the management. The management also admitted the suspension of the work lady for violating standing order rules with payment of subsistence allowance during the pendency of the inquiry and the formal disciplinary proceeding. It is also averred that the work lady was in caution period prior to the instant case for previous misconduct under the standing order. Thereafter, the management, on being dissatisfied with the explanation of the work lady, decided to hold disciplinary inquiry proceeding, and the charge sheet was given to the work lady for her defense, and also asking her to get assistance of a co-worker. The management engaged an independent inquiry officer and appointed so-and-so as presenting officer, and asking her to be present on 19/5/2018 for the inquiry. But the work lady, appearing before inquiry board on 19/5/2018, prayed for taking legal assistance of an advocate, which was denied. Thereafter, the work lady did not cooperate in the inquiry. It is further stated that the inquiry was done following the due procedure, and management, after careful study of the inquiry report, rightly terminated the work lady. In trial, the work lady herself submits her evidence on affidavit. On the contrary, the management side submits evidence on affidavits of its two witnesses, and both sides' witnesses are duly cross-examined by the adverse party. Now let us discuss the issues states herein above with the reasons therefore. Now, the issue number 1 relates to whether the management has conducted the domestic inquiry as per provision of law. The admitted position of the case are that the work lady is an employee under the management, and during her service, the work lady was at first suspended. Thereafter, she was terminated from service after holding a disciplinary proceeding. The witnesses of the management side in evidence asserts that the work lady was found committing misconduct towards the management by wearing doctor's apron despite repeated objection, and she was also repeatedly used to send MMS marked as Exhibit 3 intimidating and threatening voice messages and pictures to the HR head Sri so-and-so. in the month of so-and-so to so-and-so through WhatsApp. The previous inquiry report has been exhibited as Exhibit 4. That apart, the work lady by Exhibit 8.2, admitting the findings of the one of the previous inquiry report, submitted letter of apology that she had committed wrong in disobeying orders. The Exhibit 4 and Exhibit 8.2 are related to previous misconduct, but the instant case is for suspension and termination of work lady on the allegation that she used to send MMS marked as Exhibit 3, intimidating and threatening voice messages and pictures to the HR in the month of so-and-so and so-and-so. Therefore, Exhibit 4 and Exhibit 8.2 are redundant. The management side submits that she repeatedly used to send MMS marked as so-and-so, intimidating and threatening voice messages and pictures to this HR head so-and-so in the month of December 2017 to April 2018 through WhatsApp. But the evidence of the management is quite silent about the so-called words or the messages of the alleged threatening. The PW2 in his evidence on affidavit states that the work lady threatened to lower the image of the hospital. The management has produced and exhibited the alleged MMS marked as Exhibit 3. But that is without a certificate by whom that was originally prepared, as a certificate is essentially required under Section 64B, 65B of the Evidence Act. Otherwise, the electronic record permit remains not proved as per mandate of law. However, this provision of law can be waived if the evidence produced was not possessed by that party or the evidence is not in possession of the device from which the document is produced. In our case in hand, I have got something very unpleasant rather to say that the said electronic evidence produced by the management does not contain certificate as required, nor there is any explanation for inability of management to produce the same. Image being a goodwill before the public cannot be destroyed by a single person. However, it is pertinent to say that in a proceeding like defamation or threatening, the victim is to say the exact words of such defamation or threatening, and mere production of compact disc to that effect is not sufficient alone. Both sides have considered that the prayer of the work lady for legal assistance in the inquiry has been turned down. But the fact remains that the delinquent is a lady, and so under Section 12 of the Legal Services Authority Act, she is entitled to free legal service. Thus, the message under Section 12 of the Legal Services Authorities Act is quite clear. The crux of the dispute is that management did not follow due procedure in the inquiry, which is the subject matter of the case. The inquiry report is exhibited by the management side marked as Exhibit 12. On perusal of inquiry report, the letter of suspension marked Exhibit 8 and the notice of suspension issued by the management marked as Exhibit 7 showed that the inquiry was conducted, but nothing has been produced to show about the alleged charges on which the inquiry was initiated. It is the due procedure that the employer or management, on being dissatisfied with the explanation of the delinquent employee in the preliminary inquiry, if the employer or management decides to hold inquiry disciplinary proceeding in that case, the employer or the management shall have to frame charges of the allegations and to appoint the inquiry officer along with the presenting officer for the management with documents and list of witnesses of the management. It is mandatory that the copy of the aforesaid charge sheet of the allegations and the appointment of the inquiry officer, presenting officer for the management with the documents relied on by management and list of witnesses of the management shall have to be submitted and served to the delinquent employee, whereafter the inquiry officer with the help of the presenting officer in presence of the delinquent employee or his or representative initiates the inquiry. The inquiry report Exhibit 12 speaks about the framing of charges, but the so-called inquiry proceeding was not produced by the management. Rather, in cross-examination of PW1, this is important, beloved. Management admits that before the inquiry, no any charge sheet was submitted in this case, and therefore the inquiry report cannot be relied on. Now, if this admission came from the management that we are not relying on the inquiry report, then it becomes open for me to adduce additional evidence. It was only at that stage that the learned tribunal ought to have switched on to the second option. And regardless of the fact, so that learned tribunal has found fault with the proceeding on two counts. Namely, there was no charge sheet, and secondly, I was not provided with the service of a lawyer. Now
She was not provided.
She was not provided with the service of assistance of a lawyer. Now, assistance of a lawyer in a disciplinary proceeding is the law is settled, and probably my learned friend will also not disagree that it comes into operation only if the adversary party is represented by a lawyer. It is not a matter of right. It is not a matter of right of an employee to have assistance to a lawyer.
So let us finish the reading here.
Yeah.
Yes.
The management side submits that the work lady wide exhibit 9 admits the sending of the MMS threatening through WhatsApp, which may amount to misconduct. But the solely admission does not mean that due procedure in the inquiry report has been followed. Therefore, I find no merit on the submissions of the management side. Thus, it has been clearly indicated that the management has not conducted the domestic inquiry as per provisions of law. Accordingly, the issue is answered in favor of the work lady. This issue 2 relates to whether the termination is legal. As discussed in issue number 1, it appears that the domestic inquiry against the work lady was conducted without following the due procedure of law. Therefore, the termination of the work lady was illegal. Accordingly, this issue is answered in favor of the work lady. Issue number 3 relates to if the termination is illegal, what relief the aggrieved workman is entitled to. It has been proved that the termination of the work lady so-and-so by the exhibit 10 was illegal as the inquiry was devoid of merit as discussed in issue number 1. Therefore, she is entitled to reinstatement in service with full back wages after adjustment of any payment already disbursed to her. Accordingly, award is passed, setting aside the suspension order and termination letter and for her reinstatement in service with arrear of all benefits as stated herein above.
So she is getting the benefit under section 17B
17B.
with effect from the date of the award.
Yes. Yes.
But an order passed in a IA by this honorable court.
All right. And that is the last drawn wage.
Yes.
Yes.
All right. Now, according to you, the sum and substance of your stand is that the management did not rely on the inquiry report.
Yes.
Right. That has been reflected in the award also.
Yes.
Therefore, this was obviously a proceeding under the second option.
Yes.
Right. And if there is a second option, then according to you, there is no need to mention in the written statement that you would adduce additional.
That becomes a right available to me.
Right.
And therefore, the issue number 2 ought to have been decided in the light of the evidence that I would lead in the circumstance. Issue number 2 is whether the termination is illegal. So first issue is whether the proceeding is illegal. The second issue is whether termination is illegal, and third issue, the consequential. Now the learned tribunal has said that the conduct of the inquiry is illegal for ABCD reasons. Now, whether or not those reasons are germane, that your lordship will examine. Leaving aside the question of charge sheet, my lord, I also admit that yes, there was no charge sheet, but the correspondences indicate that the understanding of the management was that the 25th April letter was the charge sheet, because in the subsequent letter also this has been referred to as the sum and substance of the charge. Now, the charge is very simple that you sent messages and this violated the clause so and so.
There is no proper charge. That's
standing order. This is the sum and substance, but this ought to have been elaborated in a proper manner, which has not been done. Now, in the case, if the proceeding goes for this reason, then the second, I am still entitled to show that on the facts of this case, I am entitled to.
That is under which provision, section?
No.
Which law deals with this part?
No,
There is no law. It is a procedure laid down by the Supreme Court.
This is the Ludbud Singh case.
Supreme Court says if the management relies on the inquiry report, then in the written statement, they will have to mention that they will adduce additional evidence.
Yes.
If they do not rely on the inquiry.
They have no other option. They cannot, even subsequently also, they cannot file an application.
No, if they do not rely on the inquiry report, then they can't lead evidence at all before the labor court.
No, they can lead, but to lead evidence that they would like to adduce evidence to prove the charge before the labor court, that plea has to be taken in the written statement. Just for the moment, lordship may take up that decision.
Ludbud Singh.
No.
Goel.
Oh, Shambhunath Goel, 1983, 4 SCC.
You have that judgment?
No, I have quoted the relevant position of the Ludbud Singh.
Ludbud Singh.
Page 15.
Subsequent to Ludbud Singh, this judgment. Lordship may come to paragraph 16 straight away. And this judgment was subsequently taken up by a constitution bench, which says the law laid down in this judgment is the correct law. Paragraph 16. May I read, my lord?
1 minute. Paragraph 16.
Yes.
Yes.
We think the application of the management to seek the permission of the labor court or industrial tribunal for availing the right to adduce further evidence to substantiate the charge or charges framed against the workman referred to in the above passage is the application which may be filed by the management during the pendency of its application before the labor court or industrial tribunal seeking its permission under 33 of the Industrial Disputes Act 1947 to take a certain action or grant approval of the action taken by it. The management is made aware of the workman's contention regarding the defect in the domestic inquiry by the written statement of defense filed by him in the application filed by the management under section 33 of the act. Then if the management chooses to exercise its right, it must take up its mind at the earliest stage and file the application for that purpose without any unreasonable delay. But when the question arises in a reference, my lord, this is very important. Under section 10 of the act, after the workman has been punished pursuant to a finding of guilt recorded against him in the domestic inquiry, there is no question of the management filing any application for permission to lead further evidence in support of the charge or charges framed against the workman for the defect in the domestic inquiry is pointed out by the workman in his written claim statement filed in the labor court or industrial tribunal. After the reference has been received by the management and the management has the opportunity to look into the statement before it files its written statement of defense in the inquiry before the labor court or industrial tribunal, and could make the request for the opportunity in the written statement itself. If it does not choose to do so at that stage, it cannot be allowed to do it at any later stage of the proceeding by filing an application for the purpose, which must result in delay, which may lead to wrecking the morale of the workman and compel him to surrender, which he may not otherwise do. So, my lord, what my friend is saying, that once it was held that they are not relying on the, or it is their case, they are not relying on the inquiry, then they should have taken this plea in the written statement itself, that we would like to adduce evidence on merit to establish the charge that we had leveled against the workman, and we will establish it in the court. So the purpose of this is, my lord, when an inquiry is conducted, the management establishes the charge in the inquiry before the inquiry officer. And if the inquiry is held to be unfair or bad in law, then this opportunity is given to the management and the labor court acts as an inquiry officer. So this portion, that to take the liberty to adduce evidence on merit before the labor court, the management has to take this in the pleading. Why? At the time of filing written statement. And if it is not done, then subsequently at a later stage, even if the management files an application that yes, inquiry has gone against me and would like to adduce evidence on merit, that will not be permissible. Now, this law was further examined in 2001 5 SCC 433. That is a constitutional bench judgment.
So this reference is made under section 10. And the inquiry is under 33.
No.
Then
reference is made under section 10. 33 is something different, my lord. Now, 33 comes into play when a workman who is connected with the reference is dismissed from service during pendency of the reference, then the employer will have to file an application for approval before the authority where the reference is pending. So the action of dismissal or removal becomes final only when the...
all right, now here, she was terminated after the inquiry or before the inquiry?
After the inquiry.
After the inquiry.
On the termination, she raised an industrial dispute.
Right.
That was referred under section 10 before the labor court. With the
Referred by the state of Assam.
yes, with the terms of reference. Lordship has gone through the award.
Yes, yes.
And the government has framed 3 questions for the labor court to answer and decide. First, whether the inquiry was valid. So at that time, management is aware that this is the question. So they could have, because
No, they said they are not relying. So
they are not relying on the inquiry. Then they should have taken up the plea in the written statement that we are not relying on the inquiry, but we should be given the opportunity to adduce evidence on merit. This judgment says...
So, but they have examined 2 witnesses.
Yes, they have examined 2 witnesses without the inquiry officer.
So if what you are saying is accepted,
Hmm.
then even that could not have been allowed to them to examine two witnesses.
That could not have been allowed to them, but since they have not pleaded in the written statement that we are not relying on the inquiry, whatever evidence came before the Labour Court recorded it
All right.
and gave a finding.
Hmm.
And Labour Court has given a finding on the issues referred. First issue is whether the inquiry.
In essence, the finding of the Labour Court is that the charge could not be proved.
Yes, in first, the issue was whether inquiry was properly held.
Hmm.
Labour Court, with reasons, comes to a conclusion that inquiry was there. Then the second question is, my lord. Lordship may come to page 113. What are the terms of reference?
Yes.
Whether the management has conducted the domestic inquiry as per provisions of law. Labour Court comes to a conclusion that no, it was in violation of law. And that conclusion is based on reason. Number two, if not, that is, whether the termination is illegal. That question was also answered by the Labour Court, since it was not illegally conducted, so termination is back. And the third question was, if the termination is illegal, what relief? Labour Court says yes, reinstatement with full backage. And Labour Court has come to a conclusion with reasons. Now the question which comes up before a lordship under 226 will be examining whether the award was passed with reasons. And if there is reasons in the award, and that is in accordance with law, perhaps under 226, lordship will not substitute the judgment. And lordship will not interfere with the award on technical grounds also. There is another decision of our High Court, 2016 2 GLT 874.
So you want to rely upon this Lakshmi Devamma's judgment for what purpose? 2001 5 SCC?
Now, this judgment examined the correctness of the law laid down in 1986 Shambhunath Goel, because two conflicting decisions were there. The Shambhunath Goel said that you have to file the application or take that plea in the written statement, and if you don't take it, you cannot take that plea at a subsequent stage. And there was another judgment which said no, it can be taken up in subsequent stages also.
Plea of leading evidence.
Yes, plea of leading additional evidence. That is to prove the charge on its merit.
Additional is in the context of evidence is led in inquiry, and then before the tribunal, it is the
Additional evidence to establish the allegation.
But they have examined the witnesses.
They have examined witnesses because they have, management has a right to adduce evidence. They have examined witnesses. They have not relied on the inquiry, but they have adduced evidence. So even that plea also doesn't hold good for them. Now, the question I am relying on 2001 because.
Not now, Mr. Let him finish, otherwise.
Obviously, my lord, if we
Of course. Yes.
Now, 2001 5 SCC, this is a judgment which examined the validity of the law laid down in Shambhunath Goel's case and the other case. And it was held that the law laid down in Shambhunath Goel's case is the correct law. Now, in this case, they have not relied on the inquiry. They have adduced examined two witnesses.
But could not prove the charge.
Yes, even the witnesses also did not come before the Labour Court and produce what exactly the threatening messages and the pictures are. Labour Court has taken that decision.
Yes.
So now, if your lordship remands the matter to the management for a fresh decision, my lord, it will not be in accordance with law because that will interfere with the award. And this honorable court, relying on the earlier decision, that award, if the award is right with reasons in accordance with law, it should not be. Lordship will take 2016 2 JLT, paragraph 41.
Paragraph 41.
The Honorable Supreme Court in the case of so-and-so held that attempt should be made by courts exercising power of judicial review to sustain as far as possible the awards made by industrial tribunals instead of picking holes here and there in the awards on hyper-technical ground. In so, the Apex Court took the view that unless there are patent error committed by the Labour Court, the High Court under 227 should not interfere with the findings of the Labour Court as if it is hearing an appeal. Then the Apex Court reiterated the position that the High Court has the authority to inquire as to whether the finding arrived at by the Industrial Tribunal was based on evidence and to correct an error apparent on the face of the record. High Court would be justified in interfering with an award of an Industrial Tribunal on account of patent illegality or on account of perversity. So
All right, Mr. Chakravarti, you made your point. So you could not prove the charge before the Labour Court.
Now,
That's-
yes, that is the submission of Mr. Chakraborty. Now, my submission is that the whole case proceeded on the premise that there was no charge sheet. If the case proceeds on the premise that there was no charge sheet, then where is the question of proving my charge comes? Independent of it, why that the reason.
No, but you have contested the reference.
Yes, we have contested the reference on 3 issues.
Hmm.
The number 1 issue is regarding the validity of the inquiry. Number 2 issue is the whether termination is valid or not.
Judgment to dictate.
Whether the termination is valid or not. That is the second issue. Now, the Honorable Supreme Court in Ludbut Singh's case has said, long time back, 1972, that even if the inquiry is held, even if the inquiry is held to be improper, the tribunal is under an obligation.
Mr.
to return a
Datta, please
finding.
tell us, what do you want now? What is that you are urging?
My submission on the
You
judgment.
think that the order of the tribunal is wrong? Is it?
Yes.
Why, on what count?
First of all, the finding as regards providing legal assistance under the legal authority services.
That's
That
accepted.
doesn't come.
Yes.
Regardless of the fact that the tribunal has held that the inquiry was not proper,
Hmm.
it was incumbent of the tribunal upon the tribunal to give a finding on the issue number 2, whether termination is legal or illegal, independent of whether the inquiry is
The
justified or
tribunal
not.
has said you have not been able to produce those materials based on.
Tribunal has not discussed anything in the issue number 2. I am just showing your lordship. Kindly come to paragraph, page number 110, the cross-examination of the workman.
Hmm.
Cross-examination of the workman at page 110.
Hmm.
I was initially appointed as ward girl in so-and-so hospital in the year so-and-so. Termination was done in the year 2018, and as such, I was in service for more than 19 years in that hospital. As a senior employee, I had some knowledge about the administrative rules and regulations of that organization. And sometimes I used to assist the employees as spokesman for them. During the inquiry, I filed an application for engaging an advocate for my defense. There was a first incident, and that was inquired, and ultimately I was advised to be cautious in my conduct in future. Exhibit 5 was sent by me as a voice message. The message was sent to the HR so-and-so. I did not submit a written representation containing the grievance. Exhibit 10 was received by me where it is stated that I may take help of co-worker for my assistance, but I did not do that and decided to take a legal assistance. But I was denied for legal assistance, and for that, I did not participate in the inquiry. I sent the voice messages on behalf of the worker. I put my signature in exhibit 40 as a receipt of dues. Exhibit 8.1 and 8.2 was written by me. It is not a fact that I had hampered interest of so-and-so. It is not a fact that I am habitually creating problem in the organization. Now, on the face of this admission on her part that the messages were indeed sent by her, question that ought to have been examined is that whether the punishment that was imposed on her, that is termination service, that is legal or not. As far as
So
these
what did she say in the message?
there are certain
No.
I'll just read out. It is she went in verbose. She even sent certain messages implicating the chief minister. That
Where is that?
it is. I'm just reading it out.
Hmm. Is it a part of the record?
No.
No. The
Then
messages,
don't read.
messages are not part of the record, but these deliberations are reported to the police, Dispur police station, and in the FIR those things were mentioned.
No,
Your lordship can- your
if-
lordship
if
can
the-
just-
If this is the entire proceeding is based on the messages and you were in you had the copies of the,
My lord, if
Text.
the lower court record is there, my lord, possibly I'll be able to find it out. But
no, but the learned tribunal has said that you never produced the messages. It is the finding in the.
no,
judgment.
tribunal has said that I produced the messages, but for want of certificate under 64B and 65B, those could not be.
No, Mr. Doctor, please come.
116, my lord.
Yes,
116 third paragraph, tribunal.
Second
produced-
paragraph.
Submits that she
no, no,
repeatedly used to.
but the evidence of management is quite silent about the so-called words or the
But-
messages of alleged threatening.
Now, this was provided in a compact disc, CD.
Hmm.
The recordings were taken from the WhatsApp and it was provided as exhibit 3.
Hmm.
Now, here in last part of the paragraph 3, just below that, the management has produced and exhibited the alleged MMS marked as exhibit 3. But that is without a certificate by whom that was originally prepared, as a certificate is essentially required under section 64B, 65B Evidence Act. Hello, it is not a case that we have not produced the evidence.
No,
The
but,
tribunal has found
This is
fault.
correct.
Yes, tribunal has found fault because it was not accompanied by a certificate.
Right.
Now, this gains importance in view of the fact that there is an admission by the workman herself. She never denied that now
Oh,
question
Mr.
is,
Datta, we are again coming back round and round to the same point. She has said that she has sent messages, but she has also said under what circumstances she has sent it. If you want to
Yes.
rely on the admission, then you have to rely on it whole of. You can't pick lines from her admission. She said, I have sent it, but these are good messages.
now
So
therefore.
that
my lord,
also has to be admitted.
Therefore, my lord, in the premise of this admission vis-a-vis the stand taken by the management, it was incumbent upon the tribunal to give a finding on the issue number 2. Whether regardless, independent of the defect in the inquiry, the termination is proper or not. That
But
the
you show us that the termination was proper. You argue on that.
yes.
If you can give the materials to show us, then only we'll think. Otherwise, why should we go into this?
Now, your lord, in that standing order to assign a recorder.
Where is the material which shows that she is guilty of misconduct? Where is that material?
Now, yes, my lord, may kindly see the standing order. Clause 2. No?
Record, just give me the record. Hmm. Yes, standing order, which page?
The lordship will kindly come to clause 20 point. That will be at page 8. Misconduct.
Plus 20 point.
20.1. Hey, good. You know how to go. Easy way as well.
No, this is about smoking in prohibited
No,
places.
20.1.22. That will be in page 9. Page 9. The writings are little bit smudged, my lord. Threatening, the first word is threatening. 20.1.22.
Hmm. All right,
Threatening-
so this says threatening or intimidating is a misconduct.
Any why, yes.
So therefore, whatever she has happened is a misconduct.
No,
Are
no,
you not
that-
required to substantiate the allegation? Assuming that there was a proper charge. First of all, the court feels that you never framed or never served a proper charge memo, which, if I have understood
Yes.
correctly, you are also
Yes,
admitting.
yes.
The whole matter is over at that. Nothing survives. But we agree to go a step beyond because the court recognizes the right of the management. The management is running the affairs. It is not the court. Right of the management to take disciplinary action against an employee
Yes.
if he or she is found to be, misconducting herself or himself. That right we recognize. But there is a process established by law which the management is also
Now,
to be
there,
subject to. Listen just a minute. So that process has been invoked here. You first conducted an inquiry based on which you terminated her service. Then when a reference was made, you came and said that we are not relying on the inquiry report. That much you agree. So therefore, divorce the inquiry report. You have to substantiate that she was guilty of misconduct. Correct? To do that, what have you done? You have examined 2 witnesses. So that means you have led evidence. You have led evidence. The evidence,
But not on the merit of the charge.
then it's over for you.
Don't, because,
It's a wrong legal advice, we can say.
because, my lord,
It's over.
if your lordship will see the.
No, but why did you not lead evidence on the merit of the charge? Then how is the tribunal going to rule in your favor? You don't rely on the inquiry report?
No, no, no.
You don't need evidence?
I am just trying to make a distinction, my lord, here. The
No,
evidence.
Mr. Datta,
if-
please,
if your lordship-
please appreciate this. You can make your arguments, we'll hear. We are not in a hurry. But let us come pinpointedly because these are forums of debate by the experts in legal field. We have to pinpoint our debate. The termination has to be preceded by some inquiry.
Yes.
You have done it, but you did not rely on it, right? Then in the industrial tribunal or labor court, that's a legal proceeding. If you have to sustain your termination order, you have to show that it is based on materials which are germane, leading to the conclusion that her services can be terminated. To do that, you have led evidence, but you did not bring in what is the content of, what is the intimidating message she has sent. And apart from that, even if you have brought it, it cannot be treated as evidence in view of section 65B. So tribunal has said that. Therefore, the learned tribunal has held that first of all, there was no proper charge. There is no imputation of charge. So on that, the whole matter goes. But if we show a little more leniency to the management here, let us assume we do. Then also, was it not incumbent upon you that, see, this is our conduct and therefore we terminated? You did not do that also.
Yes, my lord,
And
message.
how in Article 226, how are we going to, you are asking for reversing the finding of the tribunal.
No,
What you are
Yes.
asking for is we should set it aside. On what basis I have to hold that tribunal was wrong?
On 2 counts, my lord.
Hmm.
First of all, even after holding that there was no inquiry worth the name, it was incumbent upon the tribunal to pronounce its verdict finding on issue number 2, whether termination is legal or illegal.
Tribunal has said it is illegal because you could not.
Tribunal has said it is illegal because of the finding in issue number 1, not independent of the issue number 1.
That's true technically.
This is one, my lord. And secondly, my lord,
Hmm.
your lordship is aware of that judgment of the Honorable Supreme Court, the ECIL case, where the Honorable Supreme Court has said that even if in a disciplinary proceeding, it goes because of some defect, the court should normally remand the matter back to the disciplinary authority
Hmm.
for proceeding from that stage afresh. On this count also, my lord, it was incumbent upon the learned tribunal to send the matter back to, just as it has fallen from your lordship, that send
No,
the matter
fallen
back.
means this was on a presupposition that there has been some procedural. Obviously I did not read the brief before, so I thought the charge was set aside only on the ground that the tribunal has set aside the termination order only on the ground that no proper charge was framed. If that was the only count, matter was different. But the tribunal also held that you led evidence and you could not prove the charge. So therefore, you had a chance to establish the charge, which you failed. It would amount to giving you a second chance to do the same thing,
Yes.
which is barred under Article 20 of the Constitution of India. That is the reason we can't do it. The proposition made was on an assumption that this is what has happened. There is no
Well,
finding
the-
on merit.
Whether the evidence runs
The
into
finding
self-
on merit appears to be correct. How can you get a second chance? Will it not amount to subjecting her to the same proceeding twice?
But only point coming in between, my lord, even in the evidence, my lord, it could have been verbose as regards the.
Oh, many things could have been, should have been. We can't go into that, Mr. Datta. I think you have made your valiant
Look-
attempt. Now it is for us to dictate the judgment. Keep quiet. Yes, say aloud what you have to say. Everybody has a right to say. We are here to hear. Don't hesitate. Convince the court that this view needs to be changed. I'm open. If you don't have anything to say, take your seat.
My lord, he wants to place this judgment, my lord.
On what point?
On the on, my lord, that the course that is open to tribunal where the inquiry proceeding goes.
We'll decide it in another course, another case. These facts are,
One paragraph, my lord, paragraph 61.
Mr. Datta, you tell your management to be more vigilant, more careful next time. If they feel some employees not doing things in the right way, they should take proper legal advice and handle the matter more efficiently. These writ courts are not here to go into same matter again and again and again and give a second chance, third chance. That is not the purpose. On merits, we are not convinced that this award needs interference because the court is not convinced that there is anything to even doubt that she was involved in some wrongdoing. This appears to be matters of perception. Somebody might have felt, oh, how could she have forwarded the SMS? Maybe she had sent SMS which are objectionable, but then where are those? In a legal proceeding before a tribunal, are you not required to place those materials in accordance with law? Are you not required to tender evidence? Are you going to base your case on the cross-examination of the other side? Does it happen in the eye of law? You tell us, Mr. Datta.
No.
Can you do it? So where is the scope for this court to interfere with the order of the tribunal or the labor court?
Only I will just urge
Some point
one-
here, some point here, maybe there, but substantially, how can we set aside the judgment of the labor court on this?
only one aspect I would urge before your
Yes,
worship.
yes.
Tribunal has ordered reinstatement with full back wages.
Hmm.
Now, full back wages is not an automatic thing. Before the tribunal, yes, an employee may be entitled to full back wages,
Mhm.
but grant of full back wages is preceded by certain considerations as to whether she was gainfully employed or not.
Hmm.
Now, in her return statement, she has made one statement that I am not gainfully employed anywhere.
Hmm.
But this statement, apart from, keeping aside the one single sentence in the written statement, there is no whisper in her evidence also.
No, but is it your case that she has been gainfully employed?
No.
No, that is not. That
So,
was
so
not
Mr.
my
Datta,
case.
what to do? Tell me. Tell me, the workmen, the court has to be sensitive to the mighty management versus,
Poor workmen.
so.
But
You
the
see,
poor-
if you make out a case, obviously, that doesn't make a difference. Everybody is equal before the law. But otherwise, these are, I think now you can,
You are a senior counsel now. That I'm not going to give evidence.
Sorry.
No. You are a
It
senior
is there.
counsel now. You are a senior counsel.
I have seen, that's why I said that there is a sentence, but it is
you
there
need to
in
be,
the.
you must have been briefed. You understand. Heard Mr. S. Dr. Learned Senior Counsel assisted by Mr. M. Kalita. K. Kalita. I am always confused with M and K. There is another K. Kalita here, isn't it? M. Kalita, counsel appearing for the writ petitioner. Also heard Mr. S. Chakravarti, Learned Counsel representing the respondent, bracket work ladies. Full stop. By filing this writ petition, the management of the Apollo Hospitals. Apollo Hospital is the management of the Apollo Hospitals, Guwahati, has approached this court praying for setting aside the award dated 11/3/2020 passed by the Learned Labor Court, Assam, at Guwahati in reference case number 01/2019, whereby the three issues framed by the Learned Tribunal were all answered in favor of the work lady. Full stop. Consequently, the order of termination from service of the work lady issued by the management on what is the date of order of termination, Mr. Chakravarti?
My lord. 25/6/2018.
25/6/2018
Page 44 of the report.
was set aside. And a direction was issued to reinstate her with all areas of with the areas of all benefits,
45/6. 44.
including back wages, full stop. During the pendency of this writ petition, the work lady as applicant had approached this court by filing, sorry,
My-
you want to say something?
No.
Then
My lord,
let's
it is
take it.
23/6. I'm sorry, my lord.
23/6. 26. During the pendency of this writ petition, the work lady as an applicant had approached this court by filing IA number. Give it to me. IA number
2076
2076
public
of
2020.
2020 with a prayer to grant her the benefit under section 17 capital B of the Industrial Disputes Act 1947. Taking note of the prayer made by the applicant oblique work lady, this court by order dated 1/2/2021 directed the management to pay her the benefits under section 17B. Accordingly, the respondent stroke work lady has been receiving such benefits. Full stop. By referring to the impugn award, Mr. Datta submits that although it may be correct to say that a detailed charge memo clearly depicting the charge brought against the respondent stroke work lady was not served upon her, yet the management has taken a clear stand before the learned labor court that they are not relying on the inquiry report, full stop. Accordingly, the management had examined 2 witnesses in support of the charge, full stop. However, the learned labor court has failed to appreciate the evidence led by the management to show that the respondent oblique work lady was guilty of misconduct, full stop. It is also the contention of Mr. Datta that the management did not engage a lawyer, and therefore the question of providing the services of a lawyer to the workmen did not arise in this case, full stop. Referring to the findings with regard to issue number 2, Mr. Datta has argued that it was incumbent upon the learned labor court to record independent finding of facts on the said issue before arriving at a conclusion that the order of termination was bad, full stop. Since no such finding has been arrived at by the learned labor court, the impugn award stands vitiated in the eye of law and therefore calls for interference by this court. Alternately, it is the submission of Mr. Datta, learned senior counsel for the petitioner, that even if the court finds that there is some procedural irregularities in holding the leading to the issuance of the order of termination, even then liberty may be granted to the management to proceed afresh against the respondent stroke work lady after serving a fresh memorandum of charge upon her, full stop. Next para. Mr. S. Chakraborty, learned counsel for the respondent stroke work lady, has strongly refuted the arguments made by the learned senior counsel for the petitioner by submitting that the conclusion of the learned labor court with regard to issue number 2 is flows from and is interconnected with the findings of facts recorded with regard to issue number 1. And therefore, there is no irregularity in the impugned judgment. First up, contending that the failure on the part of the management to serve a proper memorandum of charge itself had a vitiating effect on the entire exercise and has been rightly pointed out by the learned labor court, full stop. It is also the submission of Mr. Chakraborty that although the management had the opportunity of adducing evidence before the learned labor court, yet they have failed to show that the respondent stroke work lady was guilty of any misconduct. First of, under the circumstances, there is no scope for this court to interfere with the award dated so and so. You want to say award? 11/3/2020 in exercise of jurisdiction under Article 226 of the Constitution of India. First up, responding to the prayer made by the petitioner's counsel seeking leave to initiate a fresh proceeding, Mr. S. Chakraborty has argued that the management has failed to establish the charge in a proceeding initiated under Section 10 of the Industrial Dispute Act 1947 before the Labor Court. Full stop. Therefore, granting another opportunity to the management to start afresh would amount to a second chance for them to proceed against the petitioner, proceed against the respondent stroke workload on the same allegation. Full stop. I have considered the submissions made by learned counsel for both the sides and have gone into and have gone through the materials available on record. It appears from the materials on record that the basic allegation brought by the management of the Apollo hospitals is to the effect that the petitioner had circulated certain SMSs, stroke MMSs, bringing disrepute to the hospital. First of, the HR manager of the hospitals, namely Sri Sabyasachi Roy, was the central figure of such SMS circulated by the respondent, by the work lady. Full stop. It has also been alleged that she had been indulging in similar activities even in the past and has shown intolerance towards the decision of the management. Full stop. On 24/4/2018, the work lady was placed under suspension. Full stop. On the next day, that is 25/4/2018, she was asked to show cause within 48 hours as to why the intimidating / threatening voice messages and pictures sent to the HR head in the months of December 2017 and April 2018 should not be treated as misconduct. Full stop. The aforesaid notice was apparently issued under clause 20, apparently issued for violation of clause 20.1.22 of the standing order. Full stop. Full stop. The communication dated 25/4/2018 was treated as the memorandum of charge, and thereafter an inquiry was conducted by the management against the work lady, which had led to the issuance of the order of termination dated
23/6/18.
23/6/2018. Full stop. Aggrieved thereby, the workman had raised an industrial dispute, which was referred by the government of Assam to the labor court. Full stop. Taking note of the dispute, the learned labor court had framed 3 issues.
My lord, no, the issues are framed by the government in the
Achha.
order of affairs.
Taking note of the industrial dispute, the government of Assam had framed 3 points for reference and referred the matter under Section 10 of the Industrial Dispute Act 1947 to the Labor Court. Full stop. The learned labor court had framed 3 issues for decision of the reference case, no, before the sent to the refer court, full stop, based on the same reference case number 01/2019 was registered. The learned labor court had framed 3 issues for decision in the reference case, which are as follows. We quote from page // 113. Full stop. As noted above, during the course of proceeding before the labor court, the management had taken a stand that they are not relying upon the inquiry report. Full stop. Accordingly, the management had examined 2 witnesses to establish the allegation brought against the work lady. Full stop. After taking note of the materials brought on record, the learned labor court had held that the management has failed to produce the SMS/MMS marked as Exhibit 3, which are stated to be the intimidating and threatening voice messages and pictures sent by the work lady to the HR head, Sri Sabyasachi Roy. Full stop. Full stop. It was also observed that Exhibit 3 was not accompanied by a certificate as required under Section 64B/65B of the Evidence Act, and hence such electronic record would be inadmissible in the eye of law. Full stop. On such ground, now, the learned labor court has further observed that save and except indicating that there was an inquiry initiated against the work lady for circulating certain messages which were allegedly intimidating and threatening in the perception of the management, there is nothing to show that that there was any misconduct on the part of the work lady. Full stop. On such basis, issue number 1 was answered in favor of the work lady. Full stop. Since the learned tribunal had felt, learned tribunal was of the view, learned labor court was of the view that there is no material to substantiate the allegation of misconduct brought against the work lady, the issue numbers 2 and 3 were also answered in favor of the respondent work lady. Full stop. Full stop. By filing this writ petition, the management is calling upon this court to reverse the findings of facts recorded by the learned labor court with regard to the issue numbers 1, 2, and 3. Full stop. What would be significant to note here in that upon receipt of the letter dated 24/4/2018, the work lady had submitted her explanation to the management by letter dated 28/4/2018, which is on record. Full stop. The aforesaid letter explains, in the aforesaid letter, although the respondent has admitted that she had forwarded such messages and MMSs, yet the respondent has also narrated the circumstances under which those were forwarded. Full stop. If the version of the respondent given in the letter dated 28/4/2018 is accepted, then it has to be presumed that there was no misconduct on her part. Full stop. However, merely by taking note of the fact that the respondent has admitted to having circulated forwarded the SMS/MMS, the management had concluded that she had admitted to her wrongdoings, which obviously was not the case. Full stop. Since the work lady had given explanation under which those were forwarded, which under which those were forwarded. And according to her, the same was done to protect the reputation of the hospital. It was incumbent upon the management to establish by leading cogent evidence on record that the said version was not correct, and on the contrary, the work lady had intentions of wrongdoing, thereby causing injury to the interest of the management. Full stop. However, on a careful scrutiny of the materials on record, I find that the management has neither been able to do that before in the inquiry proceeding, nor have they succeeded in establishing the same before the learned labor court. Full stop. In other words, I do not find anything on record to draw the conclusion that the learned labor court had arrived at a erroneous conclusion in answering the issues in favor of the work lady. Full stop. Situated thus, this court does not find any justifiable ground to interfere with the impugned award. Moreover, since it is a case that the management had complete opportunity to establish the charge brought against the work lady and her substantiate the allegations and had failed to do so, I find sufficient force in the submission of Mr. Chakravarti that permitting the management to proceed afresh would amount to giving them a second chance to establish the same allegation brought against the petitioner, thereby causing serious infraction to our constitutional right. First, for the reasons stated here and above, this writ petition is held to be without any merit, and the same is accordingly dismissed. Send back the reports. Mr. Datta, you have tried your best, but sometimes. Then we'll close it.
Milo. Milo will indicate the last paragraph in the order.
Yes, last paragraph will.
Protect both of us, Milo. These are
So there is one writ petition by all three.
all 5 Milo. Yes. 1 to 5 petition. 5 petitioner, 5 separate orders, Milo. The petition is 1.
So 5 times it has to be quoted.
No, Milo, once it will do, Milo.
All right, take down. Heard Ms. K.M. Mohantal and counsel for the writ petitioners. Also heard Mr. R. Dhawal and standing counsel WPT and BC appearing for the respondents. Full stop. In terms of the order dated 9/2/2023 passed by this court, Mr. Dhar has obtained instruction and submits that all the writ petitioners have been assigned temporary duties until such time the office of the vice chairman of the advisory council for the welfare of ST bracket P bracket close is formed. Full stop. Mr. Dhar further submits that this assignment will be temporary and shall not alter the service condition of any of the 5 petitioners. In support of his above contention, Mr. Dhar has produced 5 separate orders issued by the Secretary to the Government of Assam, Tribal Affairs, bracket plain, bracket close, department, dated 15 February 2023, pertaining to all the 5 petitioners. First up. The orders are similar in nature. However, for the sake of convenience, I deem it appropriate to quote the relevant paragraph in the order dated 15/2/2023 issued in respect of the petitioner number 1, namely Srimati Chandana Sonowal. You see, it is here. You just quote this much. First up, Mr. Mohanto, learned counsel for the petitioner, has obtained instructions from his client and submits that his clients are satisfied with the present arrangement. In view of the above, nothing survives for adjudication in this writ petition, and the matter is accordingly closed.
Deep level.
এটা বোধহয় আগের
Item 7. Mr. M.K. Devnath will appear this matter, but he has some medical problem. So he is out of session. So on behalf of him, I pray to extend her filing the affidavit.
My lord, otherwise I would not have any objection, but my lord, these are, my lord, in fact, covered case. So, my lord, on last week, your lordship it passed an order, same case, my lord, I'll place the order, my lord. Because this is a, my lord, termination, which my lord attached, my lord, stigma. Without, total violation of the principles of natural justice. Enquiry was conducted behind my back, then after my lord, the impugned order was passed. Well, this will cover my case, my lord.
I don't know.
So where is the order of termination?
My lord. Order of termination, page 23, annex of 4, my lord. There is reference of an inspection report, my lord, which was conducted behind my back, and it was not served to me also, my lord. Second part, my lord, is stigmatic.
And where is the order of appointment?
Yes, my lord, at page 18, 17/2009. Since then, my lord, I have been serving as GRS, my lord, Gram Rojgar Sahayat at Joyanagar Gaon Panchayat under Binnakini Development Block without any blemish, my lord, from any quarter. Page 18, my lord, annexure 1.
So it was extended from time to time.
My lord.
This is a covered case.
Yes. Only one aspect is there, my lord. If your lordship comes to page 19, my lord, this is my lord, purportedly a show cause.
Hmm.
Now, my lord, may I read it? On perusal of the report submitted by the CEO, this, my lord, report was never submitted to me. Ojai in his letter number so and so, it has come to the notice of the undersigned that you were reported to have involved yourself in preparing false muster rule so and so for an amount of 185,472 in connection with implementation of scheme, namely repair of road cum bund so and so in Joyanagar GP under Bindagini Development Block. In view of above, you are required to submit your explanation as to why you shall not be terminated as per terms and conditions laid down in the contractual agreement, since the activity amounts to criminal offence and exhibits financial irregularities on your part and is unbecoming of a employee in contractual service under the department. Your written clarification in this regard to be submitted to the undersigned on or before 5th August. Next page, your lordship will see, I have submitted, my lord, before the time limit. I have submitted on 4/8, page 20. My explanation is here. This was absolutely not considered, my lord. To the commissioner, subject reply to show cause, your letter number so and so, para 1, my lord. That, sir, the allegations of preparation of false muster roll number so and so in respect of the implementation of scheme, namely repairing of road come bund from so and so, are completely false.
So your matter is not principles of natural justice.
Natural justice, my lord.
How? You have been given a show cause.
My lord, I have been given a show cause. Your lordship will kindly see, my lord, the order. The order.
No, Mr. Talukdar,
My
you see, let's be clear on a few things.
My lord.
Your case stands in a slightly different footing than the other cases. You agree with that?
My lord, I agree.
No, you agree or
On
not?
facts, yes, my lord, but
Yes.
on principle,
Then
no.
we'll give him some time because he has a right.
Brief
If it is
also
a straightforward open and shut covered case, then the matter was different.
Yes.
Then I would have disposed it of
But
today.
if your lordship sees the impugn order, my lord, there is.
Oh, Mr.
Yes, I
Talukdar, I'm
understand,
not
my lord.
saying you
Yes.
don't have a case,
My lord, my lord. My lord.
but it is not an open and shut covered case.
My lord,
So she's asking for time. So
Right.
we'll give her 2 weeks time.
my lord. Lordship fix a date, my lord.
All right, yes, heard Mr. S.K. Talukdar and counsel for the petitioner. Also heard Ms.
and Bora.
N. Bora, learned counsel, appearing for the department and submit that her colleague, Mr. N.K. Dabnak, who is handling this brief, is out of station due to some medical emergency. Stop. Therefore, this matter be posted again after 2 weeks. Considering the ground on which the prayer for adjournment has been made by the learned departmental council, the same stands allowed. Register to list the matter again on 9th of March 2023 as a fixed item.
My lord, obliged.
Okay.
In this case, my lord, the department file an affidavit of opposition, my lord.
Hmm.
I have to file an rejoinder affidavit, my lord. Kindly 2 weeks might be granted.
Mr. Your name,
K.
please?
Kolita.
Mr. K. Kolita, learned counsel for the petitioner submits that a copy of the affidavit in opposition filed by the department has been served upon him, but he be granted 2 weeks' time to obtain instruction and file rejoinder. Ms. N. Bora, learned standing counsel, PNRD Department Assam, and Ms. M.D. Bora, learned government advocate Assam, are present on behalf of the official respondents and do not have any objection if the prayer is allowed. In view of the above, let this matter be listed after the rejoinder is filed by the petitioner.
Bless.
Item 9. May please, your lordship. In this case, respondent was supposed to file counter affidavit, my lordship.
Who is for the respondent?
Yes, full Indian.
Nobody is present.
No, nobody is present.
We'll give them 2 more weeks time and then see. Heard Miss
Are we going?
R. Begum, learned counsel for the petitioner. None has appeared for the respondents. Although the name of the learned standing counsel is shown in the cause list. I also find that no counter affidavit has yet been filed by the respondents. Be that as it may, in order to avoid any prejudice being caused to the respondents, this matter is being adjourned for a period of 4 weeks. So as
Time.
4 weeks, so as to enable them to file affidavit.
Give it
If
to-
no affidavit is filed on or before the next date fixed, this matter will be taken up for disposal on the basis of materials available on record. We'll list this case accordingly. Yes.
My pleasure, your lordship. This is a content case for compulsory appointment, my lord, out of second litigation, my lord. This content case was filed in the year 2020 out against the order at 28/6/2019, my lord.
Where is the order?
Order page, start from page 27, my lord. A relevant person is page 28 and 29.
Yes, who is appearing?
Here, he's after the honorable court order, the case of the petitioner was placed before the DLC twice. Latest on minute is available with us on 31/12/2021.
Hmm.
It was placed and the DLC has considered. Kindly have a look at the minutes of the DLC. Because of the vacancy, non-availability of vacancy, the case could not be considered. Kindly come to page 2, second page.
Yes.
Orijit Sonar, he is the petitioner at serial number 1. And the executive engineer PWD Silchar Sonai Dholai Territorial Building Division Silchar placed the above mentioned proposals pending for recommendation for appointment on the compassionate ground. The matter was discussed thoroughly and decided that since there is no post available in the respective office and also in other offices of the district under compassionate quota, the executive engineer may take suitable action as per clause 15 of the office memorandum by sending the pending proposal to their head of department. In the DLC, they found there is no vacancy in the department as well as in the other department in the district. Therefore, DLC has told the executive engineer to take up with the head of the department at the government to explore whether in the other districts there is vacancy or not. But clause 15 says if the vacancy is not available in the department, then the vacancy in respect of other departments. DLC found that there is no vacancy now. Therefore, it could not be considered.
That was not correct position, my lord.
Then you file affidavit.
My lord,
Bringing this, we can.
my lord, just a moment. DLC has filed the affidavit on my lord, they have filed, my lord.
DLC is not a party here.
My lord, respondent number 3, my lord.
He is an individual. He is not the DLC.
Respondent number 3 has filed the affidavit, my lord.
Hmm.
The deputy commissioner of Kachar, who was the chairman of DLC at that time, my lord.
Hmm.
The affidavit was filed in the year 2020, my lord.
Hmm.
2/9/2020, my lord. Order was passed, my lord, in the year 2019, my lord.
Hmm.
To consider the case of the petitioner within a period of 3 months, in the respective department, if no available vacancy is available, then we take up the matter with other department, my lord. But in the said reply, my lord, affidavit of opposition, my lord, they suppress the material text, my lord, that at that time there is vacancy, my lord. But respondent have suppressed that materials, my lord. Against that, man, I have filed a reply, my lord. Affidavit reply, my lord. Showing that at the time there are available vacancy in other departments, my lord.
Which department there was vacancy?
My lord, there is number of vacancy, my lord. Okay. Which indicates, my lord, the LC meeting held on 6/2020, page number 8 of my reply, my lord. And commandant of 6 FPPN, my lord, there is a vacancy. And superintendent of police, Kachar, there is a vacancy, my lord. I have incorporated that.
All right, so who will file this affidavit?
The respondent number 3 earlier deputy commissioner, my friend appears, no? And for the respondent number 1, commissioner and secretary, I am appearing. The PWD department. The department has already sent the proposal to the deputy commissioner. They have placed it on before the DLC on 31st of December again. They said
31st of December, which year?
2021.
Yes.
2021.
But
They said that there is no vacancy.
But he is relying on materials which shows that there are vacancies.
It was of
2020.
6/2020, my lord. 6/2020. My order was passed in the year 2019, my lord.
But you have to implement the current deputy commissioner.
I have to improve about that text was suppressed by that deputy commissioner at that point in time. I'm a court petitioner, my
So
lord.
that will handle, but you want only a verdict on suppression or you want a job?
My lord, the other court petitioner, job, my lord, that was deferred, my lord. Spending 6/2015, my lord. But that's why
Maybe,
that
but we have to see whether it's a deliberate violation of the court order.
that is true, my lord.
Then how, if we find there is a violation,
Yeah, my lord.
then we can't proceed against them unless we implead them. Is it not?
I'm not allowed to include my lord.
You also file your affidavit.
But for respondent number 1, I'll file.
Your name, please.
JP Chauhan.
Mr. JP Chauhan, learned counsel is present on behalf of the petitioner. Mr. D. Nath, learned senior, as individual,
It's a contempt matter.
Then
One,
counsel-
respondent number 1.
appearing for the respondent number 1, has produced a copy of the minutes of the meeting held on 31/12/2021 of the DLC Kachar to indicate that no vacancies were available so as to comply with the court's order passed on
28/6/2019.
28/6/2019.
19.
And therefore, the petitioner's case could not be considered. Mr. Chauhan has however referred to other materials placed on record to show that the said projection is incorrect. If that be so, the stand of the respondent number 1 must be brought on record in the form of an affidavit. Mr. Nath prays for and is granted 3 weeks' time to file affidavit on behalf of the respondent number 3. Respondent number 1. Ms. K. Phukan, learned counsel is present on behalf of
Respondent number 3, Your Lordship.
Earlier DC.
respondent number 3, who
Earlier-
submitted that our client is no longer the deputy commissioner of Kachar district. At that, Mr. Chauhan has sought leave of this court to file appropriate application for impleadment of the present incumbent in the office of Deputy Commissioner Kachar. Let this matter be listed accordingly.
Supplementary list for orders, item 26.
I see.
I see.
Yes.
Well, I have received the instruction from the deputy commissioner Dhubri Malan.
Hmm.
The instruction says that on 14th of February, they held a meeting the DLC meeting is there. And they have considered the case of the petitioner, my lord. Because of lack of vacancy position, it could not be considered earlier.
Your client's case has been recommended
They have recommended.
by the DLC.
Yes, can I have them a copy?
Yes, yes, I'll provide, I'll provide, I'll provide the copy.
Hmm. Now it is for the SLC.
Yes, my lord.
But also for the department, because they have recommended his name for grade 3 post subject to availability of vacancy in the parent department, because the parent department's information is still not with them. They have otherwise considered the case that he is eligible for
So are you still giving compassionate appointment?
But those old cases which were pending. Otherwise, my lord, since April 2017, that scheme is no longer there. Now compassionate family pension has come, which were pending, and the honorable court order is there, my lord. Pending cases, my lord, they have to consider. My lord.
Give him a copy,
No, I'll-
let him examine. Heard
I'll-
Mr. M.O. Mondal,
I'll-
Learned Counsel for the writ petitioner, also heard Mr. D. Nath, Learned Counsel appearing for the, you are for whom?
Respondent number 1.
And you are for?
So the deputy commissioner, he already got transferred from the present DC. I got the information.
All right.
My- Friend's client he is also no longer there.
I also heard Mr. D. Nath, Learned Counsel, who has obtained instruction as per the order dated 10/2/2023, passed by this court, and has produced the same. As per the written instruction dated 15/2/2023, it appears that the case of the writ petitioner was considered by the DLC at Dhubri, and his name has been recommended for appointment against a grade 3 post, subject to availability of vacancy in the parent department. Full stop. Mr. Mondal prays for 3 weeks' time to seek instruction. Prayer allowed. Mr. D. Sharma, Learned Counsel, is present for the erstwhile Deputy Commissioner of Dhubri District. On the request of Learned Counsel for the parties, this matter stands adjourned for 3 weeks.
May it please your lordship, my lord, in this case, service of the respondent number, my lord, 16 and 19, is, my lord, not complete. The order of the lodgment of yesterday, my lord, directed to take service.
So you take fresh steps?
My lord, along with another, my lord, in addition to that, I may be allowed to cause service through respondent number 5, my lord. Otherwise, for many cases. In addition to that, my lord.
Who is respondent number 5?
Respondent number 5, my lord, is the executive another Kokrajhar, my lord, under respondent number are working, serving under him, my lord.
Who is appearing for respondent number 5?
My lord, I appear, my lord, for the UPDCL.
So why don't we allow him to serve notice on the respondent number 16 and 19 through you?
My lord, like he has suggested, my lord, it may be in alternative mode, my lord,
All right.
but he may be allowed to take.
Take down. Heard Mr. F.
M. Hussain.
M. Hussain, Learned Counsel for the Power Department. Petitioners. Also heard Mr.
A. Borua, my lord.
A.
Borua.
Borua, Learned Standing Council, APDCL, and Miss M.D. Bora, Learned Government Advocate Assam, appearing for the official respondent. Perused office note dated 15/2/2023. Stop. Mr. Hussain submits that he will take steps. He will take fresh steps for service on notice upon the respondent number 16 and 19 by registered post with AD as well as usual process. However, since the respondent number 16 and 19 are employed under the respondent number 5 as an alternative means, he may also be permitted to serve notice upon the respondent number 16 and 19 through the respondent number 5. As an alternative, additional means. Mr. Borua submits that if that is taken as an additional means of service of notice upon the respondent number 16 and 19, he would have no objection. In view of the above, petitioners counsel to take fresh steps for service of notice upon respondent number 16 and 19 within a week from today. In addition, he is also permitted to hand over copies of the writ petition along with written up notice upon the learned counsel for the respondent number 5 for service on respondent number 16 and 19. The aforesaid process be completed within 10 days from today. This is matter again after 4 weeks with appropriate note.
I'm obliged, my lord.
For hearing item 12.
Your Lordship.
Yes.
Your Lordship may kindly take up item number 16, Your Lordship. That's the last item. It covers all the facts, Your Lordship. Item number 12 was filed in 2013.
Hmm.
One 1148 of 2021, Your Lordship.
Yes.
If I may, Your Lordship. Your Lordship, this matter pertains to the interstate seniority of rangers in the forest department. There was an advertisement, Your Lordship, in the year 1989. There, 1989, Your Lordship, I read out the first paragraph, which is the relevant paragraph, Your Lordship. Applications for 18 stipendiary studentship for 1989 to 91 Rangers course in forestry for State Forest Department, Soil Conservation Department, and District Council at the Eastern Forest Rangers College, Kurseong, to be commenced on 1st of May 1989.
You're reading from where?
Page number 19, Your Lordship. Page 19. Annexure 1148. 1148. Item number 16, Your Lordship. 1148.
Page number 19.
Page number 19, Your Lordship. In fact, if it is convenient for Your Lordship, I have prepared a document reference of.
Give us.
Yes. Yeah. This. Yes. Your Lordship, the advertisement at Annexure A, which is at page 19, was for 18 stipendiary posts.
Yes.
The petitioners applied, the private respondents are also applied. Thereafter, Your Lordship would kindly come to page 31. There was a list of 44 recommended candidates. Page
Okay,
40.
just give the facts on the
Yes.
list of dates.
Yes, yes. There were a list of 44 recommended candidates, Your Lordship, which comprises of both the petitioners as well as the private respondents. Thereafter, there was a select list appointing 18 candidates. In the select list, which was published containing those 18 candidates, Your Lordship, petitioner number 1 was placed at serial number 5. Petition number 2 was placed at serial number 9. Petitioner number 8 and 9 found their place in item number serial number 3 and 13. Respondent number 6 and 7. Their names did not feature in those selected 18 list, Your Lordship. Thereafter, when they were stated to undergo the course in Kurseong, what had eventually happened is that the course in Kurseong in West Bengal had already started. So the students could not be sent to the Forest College in Kurseong. They were brought back to Assam and they were deputed to undergo in-service training at various subdivisions. That might be relevant, Your Lordship. The Lordship would kindly see at page 37. Page 37. Annexure E.
This matter will take some time, obviously.
Yeah.
So there you go. We'll call you again.
Page 37, Your Lordship. Your Lordship will kindly come to page 37.
Page 37.
Page 37. This
So
deputation.
can anybody just give the nutshell, what is the issue?
What has happened, Your Lordship, was there was a selection advertisement for selection of 18 posts. 18
Posts of what?
stipendiary rangers, your lordship.
Stipendary rangers.
Yes, your lordship. They'll be undergoing in-service training. While they'll be in training, they'll also be deputed for in-field training, your lordship.
Right.
Out of, eventually, there were 44 list of candidates recommended, out of which 18 were selected. I was placed in serial number 3, the petition number 2 was placed in serial number 5. So there was an APSC merit list. Out of those 44 candidates, 18 were selected. The rest did not make the cut. The rest, which includes the private respondents also, they preferred a representation before the authorities. That since we had already participated in the process, we also need to be taken in. Thereafter, when we were deputed in in-service training, the 18 of us, we were brought back because then the Jalukbari Forest Rangers College had started in 1989.
So your clients in all this writ petition were also amongst the 18?
Yes, yes. And we had a certain merit standing in the APSC merit list. Now, subsequent to a parallel process, in fact, what is important, your lordship, is that the process was carried out by the APSC. Thereafter, the ones who did not make the cut into those selected 18, they represented before the authorities and they were brought into the fold, the same as the petitioners, in spite of not having been selected, the 18. Thereafter, there was an office memorandum, your lordship, which stated that the inter se seniority of the rangers will be as per the merit list. That OM was superseded by a subsequent OM, which stated that the APSC merit list will not take into account. Now, this is where our grievances arise, because we had a particular standing in the APSC merit list. Thereafter, a draft gradation list was published. Purportedly, your lordship, we had made an averment that that draft gradation list was never published and circulated. But be that as it may, that was a draft gradation list. That was not a final gradation list. And on that point, this honorable court on an earlier occasion had raised 2 queries, whether it is pertinent to publish a final gradation list and the subsequent OM as per the merit list, which was superseded. That was based on a order of this honorable court. That copy was sought for. The forest department had not provided a copy of that. We have obtained a copy of that. That pertained to a very different matter altogether. Thereafter, my juniors, and not just juniors, outsiders, in fact, were not in the 18th. They were promoted in 2012. That is when we came and approached this court in 2013 by filing the first writ petition. While that matter was pending, in 2020, there was another OM which was issued, which stated that the APSC merit list shall be followed for fixing the inter se seniority. Now that suited our purpose, but that is what we wanted. We moved this honorable court for execution of that OM. The honorable court directed that the APSC merit list shall be the base for fixing the inter se seniority. That was the direction given by this honorable court.
Is your case covered by the Rafiquddin judgment? Are you aware of the Rafiquddin judgment?
I'm not aware, your lordship.
Not aware, my lord.
You are not aware.
Let to go through.
Rafiquddin judgment says in service, insofar as promotion is concerned, the entry, the competition, only the people who come into the service through a valid process, they can only compete. Somebody who does not enter through a valid process, they cannot claim any right over others.
I have relied on Mukul Soikia versus State of Assam in 2009, where this honorable court had stated, the Supreme Court had stated, in fact, your lordship, that the number of advertised posts, only those have to be filled up, and more than that, there has to be a separate advertisement. I bought that judgment, your lordship.
Yeah, but the shoe pinches somewhere else.
Yes, yes, absolutely.
Then why are you going somewhere else?
Yes, absolutely, your lordship.
You want seniority, not to throw them
I
out.
want seniority.
Then you are not prepared with the right judgments.
But I can ask.
Are you against their appointment or you want your
Now,
seniority?
your lordship, what has happened? If I mean, your lordship, there are 2 sets of promotions have already taken place. One in 2013-12 and the other in 2021, when they will stay operating also. So now, your lordship, a lot of water is flowing on the bridge. What I would pray, subject to what your lordship deems fit, your lordship, that I be accorded the seniority from the day my juniors, not juniors, my outsiders are promoted. That is
That's the final decision.
That is the relief I see. Otherwise, the prayer which I have been sought for in the writ petition is that I should be promoted in place of them. But now that I understand, your lordship, 10 years have passed by and they have gone to a subsequent promotional post of DFO. I'm an ACF still.
Mukul Saikia's case was, there was regularization on the basis of cabinet memorandum. If I remember correctly, is that?
Yes.
This is what happened, Your Lordship. In fact, the order of this honorable court, which directed that the APC merit list.
No,
The
madam, that
guiding factor.
was reviewed.
That was.
Let him
lost.
finish, let him finish.
So
No, nobody is in a hurry.
No.
We will hear, everybody's case has to be heard.
when this honorable court had directed that the OM be acted upon and the APC merit list be finalized for interstate seniority.
Hmm.
Unfortunately, the forest department, without reviewing or appealing that order, had superseded that had kept in abeyance the
All right,
same.
so let us go into the facts.
Yes.
You argue on the materials on record.
Yes, Your Worship.
Yes.
My lord. The private respondents represented by senior counsel Mr. Ken Chaudhary, my lord.
Hmm.
My lord, he is now in Supreme Court regarding one very important matter. So from his chamber, yesterday he requested me to, my lord, is it possible to take it in the next week? Because
No, next week, no. See, these matters you should sort out outside. Because some senior counsel will be busy, somebody will be in the High Court, somebody in the Supreme Court, somebody maybe even beyond. We are not getting dragged into this.
lordship,
We will pass an order of adjournment saying that all parties have agreed. If somebody has a problem, we'll go ahead with the hearing. Nothing can be done. Because you see, the public thinks that the judges are doing nothing, adjourning matters.
It's not like
therefore,
earlier. also
we
this
can't
matter
help
was
it.
heard twice or
We can't-
thrice by learned honorable.
That's all right. We are on today. We have no problem in accommodating Mr. Chaudhary's prayer. But then all parties should agree. We can't help it. What do I do? I'm sitting here to hear matters.
Lordship.
What do I do?
Yesterday also I talked with Mr. Counsel for the
Because this
petitioner.
prayer was
You
made
should have sorted out outside.
with utmost respect to my senior, Your Lordship, this prayer was made before this court on the earlier occasion when Mr. Chaudhary, my senior, was engaged in a different
You are
matter.
there, you are good.
Yes.
You are
No,
there.
my lord, this party has also yesterday said that
It will be difficult. We can't be just adjourning matters for the asking. These are hearing cases, old matters. These have
No,
been
Lord,
fixed today.
in some cases, this private respondents are not party in their petitions.
So all right, you take that plea when
These
you,
things are there, my lord, and some Supreme Court rulings are, my lord, before the learned council is
Mr.
engaged by the.
Mr. Goswami, these are all merit.
Merit.
You are saying adjourn, then you are saying he has a bad case. What sense does it make?
Because
Adjourn is something, is a difficult thing because the people are asking for orders. If there is urgency, then we'll hear. If all of you agree that it can be adjourned, then it's all right. We have no problem. But adjournments are creating problems. These cases are listed on a request. Then suddenly there is a request for adjournment. You agree. And again, we have seen that prayers are like, I can't do it tomorrow. I want to do it on that day. These are things that will be difficult to accommodate. Sometimes there may be matters which are very urgent requests, but otherwise that option is not there. That you will do cases on a date which only suits you.
now in all the other days, my lord, he was present. In all other days, my lord.
I understand. You agree.
But-
It will be a consent order. The
Lord,
litigants will also
if the
have to
learned
know that.
counsel agrees, my lord, only I
Yes, sir.
request him,
No,
because
that's fine.
yesterday also I informed
I'll
him.
agree for a date, Your Lordship, subject to what Your Lordship deems fit. If my-
Agree on a date.
Next week.
Next week, and
Next week, you forget 4 weeks.
next third days.
Next
Thursday.
4 weeks you forget after that. We have other business. We have fixed up other matters.
Lordship.
Next 4 weeks is not possible. Look for a date after
अपने
that.
आगे बोलो भाई वो. Date to date number 12. नहीं, private respondent.
No.
Ideally, if I just submit, Your Lordship, subject to what Your Lordship deems fit, it's the forest department, ideally,
Hmm.
who has carried out the entire exercise that I'm challenging. This is my humble submission. Lordship will fix a date. I cannot have an objection to it, but
We will be the leader party.
why?
We are the main respondents, my
You
lord.
will not be losing it.
They have not implemented, these things are there, my lord. So, sir, next week, what on in year date?
Next week, the sport is a problem. It's a 10-year-old matter.
Any
Choose a date after 4 weeks. And we'll say that on the request of all the parties and as agreed to by,
my lord.
on your request and as agreed to by petitioners council. Agree on a date? Agree on a date?
Marshal. Marshal
Agree on a date?
later.
See, we are always ready to hear matters. If you want to take time, what can we do?
Please take it.
Yesterday also, the court was asking, requesting lawyers to come and argue. Nobody is coming.
In fact,
On 21st of March.
16th of March, let it be
Oh,
4 weeks on the dot if your lordship does not.
16th of March, your matter will not be taken up because many cases have already been fixed. You still want it, you take it.
14th of March, your lordship. 14th.
There, your item will be 55 or 60, something like that.
Any date as per
What
law.
happens is 90% of the cases are fixed and then people take adjournment. And then they ask for a date. We don't know on that day what case is there. Then there's a big list. We can't even come prepared reading the brief because we don't know where there will be an adjournment prayer. And in the process, what happens is things which can be wrapped up in 15-20 minutes, half an hour, it takes double the time. Court's time in the working hours is very precious. Matters are waiting to be heard and decided. So you have to be also very sensitive to this. You have to be sensitive to this. How do we proceed otherwise? How do we make this system work? We have to devise some method to make it work. We fix matters on consent. Then we come prepared with by reading the brief, and then suddenly somebody says, I have another case in some other court. Oh, that's creating problem for the system. Judges also need to focus on a matter to hear. These are 5 read petitions. How many read petitions?
5 read petitions.
These 5 read petitions were fixed.
2013 onwards. In fact, the last occasion also, your lordship had observed that no further adjournments have been made.
These matters were fixed in the top of the list of hearing. That means everybody knew that these are to be heard and taken up. It's very disappointing to say the least. You choose your date and little bit. Next matters, court. Oh, very sad.
Item 11.
This has come up as a perfect matter. The matter related to a driver in the Central Industrial Security Force was accused of investing alcohol.
Yeah, just a minute. We'll dictate the order in the other matters. No, it's not item 12. This is a series. 12 to 16. You're right. Heard Mr. M.K. Sharma, learned counsel appearing for the writ petitioners. Also heard Ms. A. Gayan, learned CGC. You are there in this case? No. Mr. D. Gogoi, learned standing counsel, Forest Department, Assam. Mr. R. Majumdar, learned counsel representing the
Respondent numbers 5, 6, 7, 8.
5, 6, 7, and 8, as well as Mr. R. Goswami, learned counsel appearing for the private respondents. These matters were earlier fixed. Miss P. Sharma, learned counsel, is present on behalf of the respondent number 6. These matters were fixed today at the top of the hearing list with the consent of learned counsel for both the sides. However, today when the hearing had commenced, Mr. Goswami, learned counsel for the private respondents, has sought adjournment on the ground that the senior counsel engaged in this matter is not available. Full stop. These cases are fixed on the basis of consent of parties with an idea that the court will hear and dispose of these matters. However, sadly, when the matters are taken up, prayer for adjournment is invariably made by one side or the other, as a result of which these old matters are getting unnecessarily postponed. Full stop. The difficulty is that the issues involved in these cases are so complex that if the court delivers a judgment without hearing one of the parties, it becomes a ground of challenge, creating multiplicity of litigations. Under the circumstances, this court is left with no option but to adjourn the matter. Full stop. As agreed to by learned counsel for all the parties, let these writ petitions be listed again on 16th of March 2023 as fixed items.
Item 11.
You have given item 11, is it?
Yes.
All right. So why did you call 12 earlier? Achha, achha. Okay.
But here the petitioner was serving in the Central Industrial Security Force as a driver.
Hmm.
And on the allegation that he was intoxicated on duty on the date of his reporting to his place of transfer. And on the other charge that he was punished many times earlier, punishment of the removal from service was imposed upon him by the discipline authority, and later on,
Hmm.
appeal did not interfere with such an order, but on revision, he was given the punishment of compulsory retirement that we had challenged. Whereas the primary grounds I had shown on the earlier occasion, I'll show it again. None of the witnesses said that he was in an intoxicated condition, save and except that there was some smell and that he was appearing normal. The inquiry officer went ahead to cross-examine the petitioner during the inquiry proceedings. The doctor who had given the certificate saying that there was ingestion of alcohol, the breath analyzer test was taken. He was not examined even to prove the medical report, and on these grounds, my lord, the counsel for the respondent was required to take instructions as to the reinstatement of the petitioner if the disciplinary proceeding is set aside on those two grounds, my lord. But if allowed, my lord, I can go through the evidence again to show that there was no evidence against him. Number one, the number two medical report was not exhibited by the doctor. It was exhibited by someone else. No one had proved it in such a manner or the contents thereof, or even the doctor was not.
And then you took a plea that the inquiry officer cross-examined.
Yes, my lord, that is there on record, both in the inquiry officer's record and also in the order of the disciplinary authority. That is there, my lord, that was that we based on the judgment of Union of India versus Ramalakhan 2018 judgment, where specifically it has been said, inquiry officers, if he cross-examines either the defense or the witnesses, it is a biased inquiry, it has to go whole, my lord. It cannot be sustained. And then there was one judgment of the division bench of the Manipur High Court, my lord, where how the intoxication is required to be proved, and even if proved to a certain extent, that termination of service in any manner would be too excessive a punishment. My lord, that I had placed before this honorable court also, my lord. So those were what we had placed upon lordship.
What is the instruction?
Regarding the termination of service, my lord, they have filed a revision petition, my lord. In the revision petition, instead of giving the punishment for compulsory
Of the removal.
the authority modified the order, and compulsory retirement from the service with effect for pensionary benefit has been imposed, my lord, by the review authority, my lord.
So he is getting pension.
He gets a pension of 2,900 as of today. If the proceedings were wrong, my lord, then if he is deemed to be in service.
But that order of compulsory retirement is under challenge.
Yes, my lord, because my guilt could not have been confirmed by any of the authorities. All three orders, the disciplinary, the appellate authority, and the revisional authority, all three are under challenge. Because my claim is that I was not guilty at all. And the inquiry proceedings were initiated by bias.
So just let's make a note of what are the primary grounds. Number one.
The first ground is, my lord, that none of the witnesses has attested to the fact that I was in an intoxicated condition.
No evidence.
No evidence at all. During the inquiry proceedings.
No evidence to prove the charge.
The charge. There were two charges. One charge was that I was punished on several occasions earlier. But if that is made a charge, every time I am punished, there will be a second charge to say that you were punished yesterday, so I'll punish you today again. The second charge cannot sustain on that ground. As for the first charge of intoxication, there is no evidence at all. The inquiry officer proceeded to cross-examine me.
All right.
And acted in a totally biased manner. The only witness who could have testified by intoxication was the doctor who had examined me, who was not examined during the entire inquiry proceedings. And the medical report was not exhibited by him or authenticated by him. There are no clinical reports to show that I was under the influence of alcohol as required by the judgments of this honorable court, my lord, as has been stated by this honorable court. Disciplinary authority, despite recording that there was that the inquiry officer had acted, had cross-examined me, proceeded to hold me guilty, proceeded to uphold the inquiry officer. The report of the inquiry.
Acha,
officer.
which is the judgment which says if the inquiry officer cross-examines, then
My lord, that is 2018. 2018. 7 SCC 680. At page 68, not 680. Starts at my language. I'm sorry, my lord, it starts at page 670 and at page 680, paragraph 32, where it refers to division bench judgment of one high court and says, an inquiry officer is in a position of a judge or adjudicator. The presenting officer is in the position of a prosecutor. If the inquiry officer acts as a presenting officer, then it would amount to judge acting as the prosecutor. When the inquiry officer conducts the examination of chief of the prosecution witness, leads them through the facts so as to present the case of the disciplinary authority against the employee, or cross-examines the delinquent employee or his witnesses to establish the case of the employer, the inquiry officer cannot be said to have an open mind. The very fact that he presents the case of the employer and supports the case of the employee is sufficient to hold that the inquiry officer does not have an open mind. Then at page 682, paragraph 33, if the inquiry officer conducts a regular examination in chief by leading the prosecution witness or puts a leading question to the departmental witness pregnant with answers, or cross-examines the defense witness and puts suggestive questions to establish the prosecution case against the employee, the inquiry officer has acted as prosecutor, thereby vitiating the inquiry. We fully endorse the principles as enumerated above.
so if it goes on this count only, it goes, then but what happens? Then it has to be a fresh inquiry.
My lord, two stages could be there. My lord. That was an incident of 2010. I have been out of service till date. Any defense witness that I might have brought in, it all goes in. I may not be in a position to bring back any person to say that day I was drunk or not, whomever I had met. I do not know where they are. For the prosecution also, in my humble submission, it will be very difficult to get hold of that doctor on that day, what he did on that day, because this medical examination taking place in 2010. What was my demeanor? How did he come to a conclusion? Nothing can become. But in such type of cases, there is one judgment of the of our High Court, which says that after this lapse of time, a remand back would not suffice anything because it is not a allegation of the level which could perhaps be continued for so long a time. It was a trivial matter. It happened. It goes. Reinstatement.
Acha, have you seen this judgment? Have you read it?
Yes, my lord. Regarding that, my lord, I'd like to submit, my lord, that is regarding inquiry officer cross-examined that plea he has not taken in that time of appeal also, my lord. Kindly see the appeal.
No, but then these are, this has a effect of vitiating the trial then.
But
And where are the judgment where there is no evidence?
My lord, the manner in which it has been proved here cannot be the manner in which it can be proved. My lord, I had given the judgment in 2014 legal Manipur 109. I had given a copy. My lord,
All right, so then we'll proceed with the matter after the lunch recess. And
I'll also have all the copies.
I'll call you. Hmm?
I'll have all the other copies ready. my lord.
Yes, you have the copies handed over to
I'll-
them. And also give her the copies.
Yes, I've given the last one.
So the matter is otherwise now on a
yes,
Narrowed
my
down,
lord.
my lord.
Yes,
narrow campus. First of all, one charge was that he has not listened to advices or his conduct was not okay earlier.
Yes.
But is it the same conduct? Is it the same offense? Is he a repeat offender or something like that? that is not there on the record, if I remember
Some,
correctly.
well, one or two punishments was related to alcoholism and of intoxication, and one or two was of sleeping on duty. But these were all minor punishments mostly, which were given to me on the spot without an inquiry. These minor punishments come without.
And also, if he was intoxicated, because he said earlier, previous evening, he did consume
Yes.
alcohol.
We had.
So therefore, to ascertain as to what was the gravity of his misconduct, if at all, there had to be some analysis of what is the level of intoxication. It appears that everybody said he was smelling of alcohol,
Alcohol,
but nobody has seen him behaving in a manner which
none.
resembles a person in inebriated state. So the charge actually is smelling of alcohol rather than.
Lordship's permission, a short list of dates of the events and the judgments.
Yes. This 5-3 movement order was to report at Duliajan
My lord,
from the IOC Guwahati.
Guwahati. Transfer order is of 4. Transfer came from the IG, Kolkata.
Revision was filed before whom?
My lord, the IG. I'm sorry, my lord, the IG. The page. Hmm? At page 127 is the order, my lord, the Inspector General, CISF,
Hmm.
notice.
All right, so let us quickly see the documents.
Lordship would find the movement order at page 21.
Yes.
Page 21 is the memorandum of, is the movement order. Page 23, my lord, is the translated version of the.
Just let us see what is there.
My lord, it says the following CISF personnel of this unit is hereby directed to proceed on regular posting to CISF unit as mentioned against their name. Particulars are appended below. Serial number 1, CISF number so and so. Unit to which posted Oil Duliajan. Railway warrant issued no. Living with family yes. CLPH is 15 days, 2 days. EL sanction or height and actual distinction authority. IG CISF NES headquarters Kolkata. SO number 2 of 2010 dated 4/2/2010. That was the authority under which he was transferred. This was issued by the Deputy Commandant CISF unit IOC Guwahati. Thereafter on 13/5/2010 at page 23 is the memorandum of charge, where the two charges are at page 24. Force number so-and-so of headquarters so-and-so had reported to CISF unit Duliajan on 16/3/2010 on transfer from CISF unit at IOC Guwahati, but he was found under influence of alcohol at about 1100 hour on 16/3/2010 while reporting to
We
his
are reading
superior.
from which page?
24, my lord. The two charges are named there.
Hmm.
Force number 97, Head Constable Driver Gautam Talukdar of Headquarters Sector CISF Unit Oil Duliajan had reported to CISF Unit Oil Duliajan on 16/3/2010 on transfer from CISF Unit ISC Guwahati, but he was found under influence of alcohol at about 1100 hour on 16/3/2010 while reporting to his superior. Charge number 2, force number so-and-so, Head Constable Driver Gautam Talukdar of Headquarters Sector CISF Unit is charged with incorrigible behavior of misconduct and indiscipline in that he has earned bad service record by being punished with 1 major and 10 minor punishments during his career, which is highly objectionable, hence the charge. Then the later pages might show the imputation of charge, imputation of misconduct, and the list of documents and the list of witnesses. The inquiry report my lord starts at, my reply is at page 36. That on 15/3 I arrived at Duliajan from IOC Guwahati to join at the post of Head Constable Driver at Duliajan. On the same day, I met one of my close friends with whom I enjoyed a night with a small party taking some alcohol. On
Which page is your reply?
36, my lord. The date unfortunately, my lord, was not typed out. My lord, it is 24/5/2010, matter of record. My lord. I admit that on 15/3/2010, I arrived at Duliajan from IOC Guwahati to join the post of Head Constable Driver at Duliajan. On the same day, on 15/3/10, I met one of my close friends with whom I enjoyed a night with a small party by taking some alcohol of the liquor. On 16/3/2010, I joined the office at CISF unit at Duliajan at about 11 AM. On that day, I had not drink a single drop of alcohol, as the smell which arises from my mouth was of the previous day. Sir, my alleged act on my part was not intentional but accidental, for which I beg to be excused and requested to waive my charge and my being my maiden offense. I hereby bind myself and assure that I shall never repeat. Thereafter, my lord, the presenting officer and the inquiry officer were appointed at page 37 and page 39 on the 31st of May 2010. Thereafter, Lordship will find at page number 41, the inquiry report starts. At page 44, I'm sorry, Madam, at page 43, the statement of one Golok Singh PW number 1 is there. Where, my lord, he says that it was at the middle of the page, my lord, at serial number 2. He says, Lordship, in the middle of the page, there will be a 02.
Page number?
43, my lord. 02 is there, my lord, at the middle of the page.
Yes.
On 16/3/10 at about 1100 hours, Head Constable EXC PKJ, who was performing duties at BHM, took aforesaid Head Constable Driver Gautam Talukdar to the office of the Commandant for presenting him to the Commandant. Then from his actions, it appeared that HC Gautam Talukdar was in inebriated condition and his mouth was smelling of alcohol, whereupon so and so. So this PW number 1 has heard it from PKJ only. At page 44.
No. How do you say he heard it from PKD?
My lord,
He said
says
PKD took him there.
PKD took him there, so he was not the person who had at any time reported. Lordship will find that the last question, then how did you adduce evidence on the basis of records only? So whatever was the written complaint given by PKD or by the assistant commandant, it was only referred to. He was not there on the scene of incident. Question number 1, did you see whether I had taken alcohol or not? No. He was not present there. That is a fact. He was the person who only maintains the records. Thereafter, my lord, at page 44, statement of the sub-inspector EXC P. Banerjee, that paragraph, my lord, from the bottom, 6th line, my lord, starts with the date 16/3/2010. Lordship, friends, made at 1340 hours as PW to X1. When I took head constable Gautam Talukdar, he appeared normal, but his mouth was smelling of alcohol. The medical officer, after examining, said that head constable Gautam Talukdar had drunk alcohol. Then, when I cross-examined him at question number 1, when I was talking with head constable Gautam Talukdar, some smell like alcohol was coming from his mouth. Then he refers in the next question, and by the inquiry officer, the certificate of the doctor. Then, my lord, just down below, it is a statement of PK Day at page 45 to the question put by the presenting officer himself at question number 2 at page 45. How did you find the condition of head constable driver while taking him to interview? Answer, everything was normal, only his mouth was smelling.
P. Banerjee is PW2.
My lord, yes. There is one typographical error at page 45. Questions put to PW2, it should have been PW3, my lord. To question number 2 put by the presenting officer, in the middle of the page, he says, how do you find the condition of head constable driver while taking him to interview? Answer comes, everything was normal, only mouth was smelling. Then he says, when I asked him, he says, what was the smell? I don't know what his mouth was smelling of. That was PW3. Then PW4 at the next page, page 46. Questions put to PW4 by the presenting officer during the inquiry. Question number 2. When you were filling up the form of said head constable driver Gautam Talukdar, was he drunk and was his mouth smelling? Answer. When I was filling up the biodata form of the aforesaid person, he was chewing something and his mouth was smelling of betel nut. I did not feel that we had consumed alcohol. That is question number 2 to PW4 by the presenting officer. Then at page 47, the PW5 comes in. who just goes by the orders which were there, different orders, past orders which showed my previous punishments. So there was no cross-examination, nothing. At page 48 is the PW6, the person who had sent me to the hospital. There,
These
my
are all your orders of previous punishment.
lord, yes, there were 11 punishments, 10 minor, 1 major.
Which is the major?
My lord, number 2. First one is 1 increment without cumulative effect, it is a minor. 2, it is stoppage of pay reduced by 1 stage. No annual increments, that is my lord, and the reduction will affect future pay, that is major. And the rest, my lord, are all 7 days fine, 1 day fine.
So this can't be a misconduct that he was earlier punished. How can this be a misconduct?
My lord,
Somebody who is earlier punished, so that itself is a charge. That since you are punished earlier, now you go. That can't be the charge. Huh? You agree with that?
no, my lord, I'll let him finish, my lord.
No, he will finish,
My lord,
but
That
you have
is-
finished him before
My-
that.
my lord, that
You have
second
finished the
punishment-
petitioner, therefore you have to answer.
My lord, in second punishment, my lord, his condition is inappropriate, my lord, he is a habitual, my lord, alcoholic, my lord, in kindly see.
No, that's all right, Ms.
Yeah.
Gayan. What we look at is you have brought in a charge.
Yes, my lord.
So you have to prove that charge.
Then
No?
I'll, my lord, that is from.
What
the-
you have proved is he was smelling of alcohol. You have not proved that he was drunk, he was in an inebriated state. That is what his argument is.
Yes, ma'am, may I commit my English?
And that we'll answer, but the question what I'm asking you is, the fact that someone has been punished earlier, is it a charge for which he can be thrown out of job? Yes or no? That's what I'm asking you. Whatever was punished earlier was on the basis of earlier proceedings.
Yes, ma'am, that is,
That is okay.
yes.
But your charge is not that he's committed this misconduct
Mm.
and it is a habitual misconduct. That is not your charge. Probably that is what you wanted to mean. But then that's not the charge. You said he was drunk and then he was punished earlier. And then you remove him from service and then you make it an order of compulsory retirement. If you say that he came to the duty in an inebriated condition, of course it is a serious matter. Of course you are entitled to enforce discipline, but you are not even saying that. At least your witnesses are not saying that. Is it a completely improbable story that someone who drinks in the previous evening might smell alcohol in the morning? It's possible. Is it not? So you are not sure whether he was drunk or he was not. And you thought, even if he is not drunk, let us get rid of him. This can't be the approach of. He's lost his job, he has a family. We are not sympathetic to people who are guilty of misconduct, who bring in indiscipline in the force. We don't approve that. But then you have to do things as per law. It has to be transparent. Which is the evidence which shows that he was drunk when he came to the duty?
My lord, kindly see, page 48, my lord.
Yes.
Page 48. my lord. Statement of my lord, Assistant Commander MS Yadav, my lord.
How did he know that he has consumed excessive alcohol? Did he consume alcohol inside the office premises? How did the commandant know? How did this witness know? Assistant Commandant MS Yadav.
My lord, kindly, the statement of that, I could assess from his action, pace and speech that he was inelegant, my lord. That is the line number in the middle of the statement of MS Yadav, my lord.
Yes, but at the same time, someone who saw him said there was nothing abnormal.
And my lord, here also that
PW4 says nothing abnormal.
And
They may be different in rank, but as witnesses, they have the same value.
in the cross examination also case 49, my lord.
Hmm.
A cross examination by that is accused, my lord. I come before 11:16 by myself. No one had assisted me, or nor did I misbehave with you there. Then how did you know that I was drunk? I have stated that you were unable to walk, or that you had misbehaved with me, but it appeared from your action on smell like alcohol was coming from your mouth. And when I asked to you that this is your first day in this unit, when you had you had been called for by the commandant for interview, why did you drink? Then you said that you had made a mistake admitting the above.
There is nothing like that in the person who was.
Then this is a question put by the accused to the Malad Yadav Malad statement of assistant commandant Malad. Then Malad.
Hmm.
And Malad case 56.
No,
Malad.
all right, let him finish then.
Yes, sir.
Hmm.
Just I'll point out where the assistant commandant says that I was not acting normal. The very person, the PW number 2, PW number 3 contradicts the assistant commandant at page 45. He says, before taking him to the commandant, I took him to the assistant commandant, and assistant commandant said his mouth is smelling and directed him to take to oil hospital. So he's the person who was there present on the scene. On cross, he says everything was normal, only mouth was smelling. So this is a contradiction with what the assistant commandant says. At page 45, Lordship will find. From the top, my lord, I'm reading. While taking him near the commandant office, page 45. While taking him near the commandant office, I got the smell of something like alcohol coming from his mouth. And before taking him to commandant, I took him to assistant commandant. And assistant commandant said his mouth is smelling and directed to take him to oil hospital. Now, in his cross, just the para below, question number 2. This is by the presenting officer, not in his cross. The presenting officer asks him, how did you find the condition of head constable driver while taking him to interview? He says everything was normal, only mouth was smelling. So his actions that the assistant commandant speaks of was not seen by this person. Mouth was smelling, my lord, that is nowhere denied. Now, if Lordship would kindly have page 51. At paragraph 9. Page 51. Much
Yes.
at the end, my lord, it is at paragraph 9, it is the statement of Constable J. Venkataswaralu. There, Lordship will find it page 52 in answers to questions put by the inquiry officer at question number 7. He had accompanied me the whole time. Did you feel from the actions of driver Gautam Talukdar or from observing that he had consumed alcohol? No, I did not. Then at question number 10, Lordship will find. I'm sorry, question number 9. Referring to your statement in response to question number 8, how can you say you did not feel from his action that driver Gautam Talukdar was intoxicated? Usually, an intoxicated person cannot walk properly, he stumbles, cannot talk properly, starts a fight on minor issue, but head constable driver did not do any such thing. Therefore, I felt that he was not drunk. Then do you want to say that Gautam Talukdar had not consumed alcohol? I did not feel that he had consumed alcohol. Now, Lordship, at page 53 is my statement. But whatever I have said, down below, Lordship will find examination by the inquiry officer. So after my statement, he makes an examination to find out, to clarify something. Then Lordship will find at page 54, middle portion, cross-examination by the inquiry officer in bold. In fact, the examination is also partly leading. But specific cross-examination comes in after he examines me.
But even if you are chewing betel nut,
My lord.
if he is going to meet the commander,
My lord.
you think it is a good conduct? How can a head constable rank employee, how can he go to the commander's room chewing betel nut?
The-
Something is wrong in his conduct.
There is something wrong with it.
Yes.
Otherwise, those one punishment, one major punishment, and the other punishments I have gone through, my lord, somewhere of sleeping while he was on the guest house duty in the chair of the guest house.
Hmm.
So at one point of time, it was sleeping at night when he was on guard at the water tap. So the issues were minor, but yes, he had made mistakes. Perhaps these were mistakes which could have been made. And I do not dispute that. Neither does he dispute that I was wrongly punished. He said that I was just asked, I was caught and I was punished. That is there. So far as betel nut is concerned, my lord, punishments, anything else than a dismissal or a termination or a compulsory retirement, which has now.
Then what is the next one?
My lord,
But below compulsory retirement, what is the next?
my lord, there were several, my lord. They could have stopped my annual increments for a year or so. They could have transferred me out from that post. They could have kept me, they could have given me a day's fine. There are several punishments which I have already been given. The minor punishments, lordship will find 10 punishments I had already been given. So those 10 options were always available to them. They were all different punishments.
Hmm.
Anything.
But it has
even
not
censured.
worked. These punishments have not made any difference.
My lord,
So what is the wrong in they taking a bigger step?
my lord, the bigger step, my lord,
Hmm.
the punishment which
See,
has
Mr.
befallen me,
Mr. Majumdar,
my lord.
11 times they found your client doing things which are not proper conduct. Correct. Major punishment, minor punishment, these are different things. But they found that your conduct was not in order.
My lord.
On the 12th occasion, you did not drink in the morning. But as per your own showing, you had consumed alcohol, you were smelling alcohol and you were chewing betel nut when you came to meet the commander on the first day in duty. That much is admitted.
My lord, yes.
So is this a conduct which should go unnoticed completely? We are running a discipline force. It's not a club or a hospital, we're running a discipline force.
My lord,
So why should you be sympathetic towards your client?
the status of the petitioner, my lord. A person of that level having chewing betel nut, my lord, it's not that I was chewing betel nut in front of the commandant. He was chewing betel nut, they had to show that it was in front of the assistant commandant. Because while taking him,
Hmm.
he could have chewed the betel nut, smell could have been there, and he might have entered, my lord. So in his wisdom, he's saying that I had chewed betel nut, I had betel nut. It does not, my lord, actually imply that he was standing in front of the assistant commandant chewing betel nut.
No, but
When
he
a
was in the
Tamil
office and he was chewing betel nut, that's what he
My
said.
lord,
Driver
or-
doesn't go to meet his ultimate superior in that.
I'll just try to find out what was the exact sentence he
He was
said.
obviously trying to cover up his alcoholism the previous evening. That was obviously.
Even, my lord, if he has alcohol on off-duty hours, my lord, that is not a named offense in the act itself or the rule itself. It is only when he consumes alcohol on duty.
Hmm.
And that has also been discussed in the judgment of this honorable court, my lord, that having alcohol at other times would not perhaps affect so much. I'm just trying to find out, my lord, what आप अपने बहन के सह कमांडेंट ने कहा कि आपके मुंह से बदबू आ रही थी, आपने शराब पिया तो आपके मुंह से किस चीज की बदबू आई थी? मैं तामुल पान खा रहा था, उसके स्मेल की. That is what he said in Hindi at page 79. And then आपको मालूम है वर्दी में पान खाना मना है. My lord's question has now come up, my lord. फिर आपने पान क्यों खाया? स्पष्ट करो. मैंने उस समय नहीं खाया था, पहले खाया. So it might be before he entered the office, he might have cleaned
You
his
are reading
mouth.
from where?
My lord, the original enquiry report at page 79, the Hindi version I'm trying to read. And here, my lord, also we'll find it in the translated version, also in the next question, my lord. Question number 3. You know it is forbidden to take betel leaf when you are in uniform. Why did you take? I was not chewing then. I had taken earlier. The answer is there, my lord. So prior to maybe approaching the assistant commandant, in the morning he had a betel nut, my lord. That could also be, my lord. Then, my lord, the cross-examination by the inquiry officer of the accused.
So where he was put to a breath analyzer.
Yes,
And that red bulb
red bulb
flashed,
flashed is what comes.
but the doctor didn't come and depose.
No, my lord, he didn't
And
come.
there was blood samples taken?
No, my lord, that is what I have stated in this, in my statement also. Lordship will find at page 53. Above the examination by inquiry officer, 1, 2, 3, 4. 10th line, my lord, 10th line. Sir, it starts with sir, my lord. So it says, sir, my statement is that I have been tested only by the machine and machines always do not give correct result. It gives wrong reading many times and it is a fact that on that day also it gave a wrong result. My blood and urine should have also been tested to get proper proof and that is a fact. But neither was my blood tested nor urine tested. Only because a red bulb flashed, it was declared that I had consumed alcohol. This is totally wrong and I did not drink on 16/3/2010. Was a stand in the inquiry. Then Lordship, while passing the impugned order, which starts at page 93. At page 94, Lordship would find,
14th September 2010.
my lord, yes, 14 September 2000, at page 94, in the middle part, 16th line from the top, if I'm not wrong, my lord, starts with the word evidence. Public documents regarding his case. Lordship, has it? While conducting the inquiry according to rules, inquiry officer recorded the statement and also cross-examined accused constable on 26/7/2010 and 28/7/2010. On 2 occasions, the disciplinary authority also records that I was cross-examined. Thereafter, my lord, at one point of time, he goes to say that yes, my lord, at page 101, where everybody has stated that I was not drunk, I was normal, it was only betel nut. Commandant goes to form his own opinion that all these people have lied. It is only the assistant commandant who has given the truth. He states so, my lord. He says which fact is at page 101, which fact is confirmed by the statements of prosecution witness number 1, witness PKD and prosecution witness so-and-so MS Jadhav, assistant commandant. Witness 2 P Banerjee during the department inquiry and also by PW1 exhibit 1 to exhibit sponsor. Although in this case, prosecution witnesses number so-and-so, witness number so-and-so, all the witnesses are named, have undoubtedly dishonestly tried to hide the true fact knowingly. But the fact during cross-examination, they have admitted that the accused was taken to Oil Hospital for medical test. And also that the accused was smelling of betel nut covertly proves the fact that he is inebriated. It goes against everybody's witness, save and except 2 persons. And PKD never said that I had drunk. PKD never said that I was in an intoxicated condition. PKD in fact has said that he appeared normal, but he was smelling. Then, my lord, I filed my appeal, which lordship would find at page 111. Point number 3, my lord.
Where is the order by the appellate authority?
Appellate authority order is at the next page, my lord, page 113. Rather, page 114, my lord. And page 116 is the relevant portion.
Page 116.
Is the relevant portion, my lord, where he refuses to, or he rejects the appeal petition.
And the revisional authorities order?
My lord, that would start at page 128. 128. Relevant portion, my lord. And my lord, at page 131.
And dictated 3 impressions. You want to come back, you come back.
At page 131,
Hmm.
My ground of the medical officer not being examined,
So page 188 is the
revision
divisional order.
in the effective portion would be at page 134. I have examined the revision petition submitted by the petitioner and other documents available in the case file. I find that the charges levying as a petitioner has been proved on the basis of evidence adduced before the inquiry officer during the course of departmental inquiry. Inquiry officers conducted the inquiry in a fair and judicious manner and afforded him all reasonable opportunities to defend himself. There is no procedural irregularity in the conduct of the DE by the inquiry officer and by the disciplinary authority dealing with the case of the petitioner. Principle of natural justice has been complied with in the spirit, and the allegations and charges have been proved against the petitioner. However, the punishment awarded by the disciplinary authority by order that it's censored for the proven charge and appeal by the appellate authority seems to be harsh. Therefore, taking into consideration the totality of the facts in the case, I take a lenient view and modify the existing punishment awarded by the disciplinary authority and upheld by the appellate authority to that of compulsory retirement from service with full pensionary benefits in terms of Rule 41 of the CCS pension rules to meet the end of justice. And he had entered service, my lord, in the year 1997 and being this compulsory retired in 2010. His pensions comes to somewhere around 2,900.
Acha, how many witnesses they have examined?
My lord, 7.
9, PW9, yes.
Huh?
1 to 9, suppose.
PW9, my lord.
And the commandant is 7.
Yes, Commandant.
Assistant commandant is 7.
PW9, assistant commandant is 7, I'm sorry. 7. 9 were examined.
Hmm.
To substantiate my lord, my assertion that the inquiry officer did not have cross-examined and that he said the whole
Which judgment?
my lord, that is Union of India versus Ramlakhan Sharma. It is 2018. 7 SCC 670. My lord, there at page.
What is the citation really? Please, can you repeat it once again?
2018. 7 SCC 670.
And which is the relevant paragraph?
My lord, paragraph 32. Lordship has the SCC on hand, my lord. Or the print of copy. At page 11, my lord. The division bench, after elaborately considering the issue, summarized the principles in paragraph 16, which is to the following effect. Lordship will have Roman 4. If the inquiry officer conducts a regular examination in chief by leading the prosecution witnesses to the prosecution case, or puts leading question to the departmental witnesses pregnant with answers, or cross-examines the defense witnesses, or puts suggestive questions to establish the prosecution case employee, the inquiry officer acts as prosecutor and thereby initiating the inquiry. Lordship will also like to have page 10, my lord, paragraph 31. In there, my lord, another division bench order has been put up. A domestic inquiry must be held by an unbiased person who is unconnected with the incident so that he can be impartial and objective in deciding the subject matter of inquiry. He should have an open mind till the inquiry is completed and should neither act with bias or give impression of bias. Where the inquiry officer acts as the presenting officer, bias can be presumed. At all events, it gives an impression of bias. An inquiry officer is in a position of judge and adjudicator. The presenting officer is the position of prosecutor. If the inquiry officer acts as a presenting officer, it would amount to judge acting as prosecutor. When the inquiry officer conducts the examination in chief of the prosecution witnesses and leads them through the facts so as to present the case of the disciplinary authority against the employee or cross-examines the delinquent employee or his witnesses to establish the case of the employer disciplinary authority. Evidently, the inquiry officer cannot be said to have an open mind. The very fact that he presents the case of the employee and supports the case of the employee is sufficient to hold that the inquiry officer does not have an open mind. Thereafter, my lord will have at page 12 of the printer, para 33. We fully endorse the principles as enumerated above. However, principles have to be carefully applied in the facts and situation of a particular case. If there is no requirement of appointment of presenting officer in each and every case, whether statutory rules enable the authorities to make an appointment and are silent, when the statutory rules are silent, then they go to discuss whether a presenting officer was necessary or not. In my case, a presenting officer is there. In spite of that fact, it is the inquiry officer who takes up the role of cross-examination. And on all questions of the presenting officer, the witnesses were saying, I did not feel. Therefore, my lord, there the inquiry officer now takes over. You are not being able to do it, let me do it. That, my lord, would be a bias as it is. So that is one aspect. My lord. The other, my lord, I have given a printout 2014 legal Manipur 109. My lord, in that case, this was very similar, where lordship will have at page 9. Therefore, if to be under influence of alcohol while on duty, it is to be treated as an offense or an act of indiscipline, he must be attributed with such acts which he would commit while in a state of intoxication. In order to penalize a person of being under influence of alcohol, he must be in a state of intoxication because of consumption of liquor, so as to render him incapable of knowing the nature of his act or to understand what he is doing is wrong or prohibited by law. In the present case, for the department to penalize the petitioner on the charge of being under the influence of alcohol, it has to be shown that the petitioner was not capable of knowing what he was doing, or that he was not aware of what he was doing is either wrong or contrary to law under influence of alcohol. It is to be noted that to be under the influence of alcohol describes a state of mind body which indicates that he was acting in a manner which his normal person would not otherwise behave, except under the influence of intoxicating liquor. However, the inquiry report nowhere mentions or discusses any evidence or finding to the effect that he was in a state of intoxication, or that he was incapable of knowing what he was doing and was not aware of what he was doing is wrong or contrary to law, or that he was behaving in a manner which would clearly indicate that he was in a state of drunkenness or inebriation to be described as under the influence of liquor. What has been recorded in the inquiry report and the analysis and assessment is to the fact that the petitioner had consumed liquor while on duty. It may be also observed that the fact that the petitioner passed his rifle did not itself indicate that he was drunk or it was an act committed in the state of drunkenness. It also cannot be said that he was in a state of intoxication as he never aimed his rifle at the patrolling party. This court is of the view that the fact that he cocked his rifle but pointed the barrel towards the sky does not in any way indicate in absence of other evidence that he was in a state of drunkenness or intoxication so as to render such an act being perpetrated under the influence of alcohol. Therefore, this court holds that the drawing of inference and conclusion by the inquiry officer that the petitioner had acted in an indisciplined manner under influence of alcohol or liquor does not seem to be based on any cogent material. The court has already held that there is no discussion of the material evidence produced in the court of inquiry, which could be the foundation of the conclusion and finding arrived at by the inquiry officer. Therefore, this court is not able to accept the finding of the inquiry officer that he was under influence of alcohol so as to render him to any penal action. The requirement of the blood and the blood and urine tests were discussed in the earlier paragraphs. Then, my lord, that even if it is proved, now, lordship may like to have page 13, my lord.
Page 13
Of that judgment itself, my lord. Page 13. Paragraph 17, subpara I am reading, my lord. It is now well settled principle of law. Lordship, Page 13. It is now well settled principle of law that it is not sufficient to interfere with any penalty, merely on the ground that disproportionate to the charge proved, but it must be shown that shocking is disproportionate to the charge proved. In the present case, if it is held that, as we have done so, that the petitioner was not proved to have been in a state of intoxication, and though he cocked his rifle, it is not pointed to the patrolling party of charge, the penalty of dismissal can be said to be shocking disproportion. Paragraph 18. Since the court
are you arguing on disproportionality or
No,
that charge has not been proved?
On the last occasion when we were arguing the matter, what it had fallen from lordship that what is it proportionate or not? So this, since his judgment continued to say that it is disproportionate, therefore I was pointing it out. That even the punishment that has been given now is disproportionate. Lordship may like to have then the Rajasthan High Court judgment that I have given, my lord. Their lordship may like to have page 3, my lord.
Yes.
The last paragraph, heard the learned counsel of the parties and produced the material available on record. The first and foremost ground for termination of petition is that he was found drunk on duty. The basis of such finding of the inquiry officer is the medical examination report. In the medical examination report, medical officers specifically observed as under conscious, cooperative, indicative, coherent, oriented, well-timed, place, name, person, alcoholic breath smell and mouth present, conjunctive, congested, talkative, concern, and concluded she so-and-so consumed alcohol but not in intoxicated state. It is not in dispute that no blood test or urine test for the purpose of examination were conducted by the medical officer. Then my lord, Chanjin Soma's case, one Chanjin Soma's case is discussed down below. In view of the above ratio, it is clear from that a charge of person being intoxicated cannot be said to be proved if no blood or urine test has been conducted for the purpose. It has been also been held that merely the alleged odor of liquor emitting from the mouth cannot be made the basis of holding a person guilty. In the present case, it was the specific observation of the medical officer that the petitioner was not in an intoxicated state. The officer found the petitioner to be conscious, coherent, and even place and time oriented. In view of the observation of the medical officer, in view of the ratio as laid down in Chanjin Soma, it can be safely concluded that the finding of guilt as recorded against the petitioner solely on the basis of odor coming out from his mouth cannot be held to be tenable. Further, who has appeared, BW number 7, who has appeared before the inquiry officer and was in charge of the quarter guard on the date of incident, specifically stated that right from the type of taking charge till the period of completion of his duty, the petitioner was not drunk. He was further stated that there was no odor of liquor in the room. So and so stated, then the Hindi version is given, my lord. And the last paragraph, my lord. A bare perusal of the contradiction of the statements has relied upon by the inquiry officer makes it clear that the facts have been improved during the inquiry proceedings and the petitioner has been sought to be implicated in the same. Analysis of evidence laid before the inquiry officer and the findings recorded by the inquiry officer makes it clear that the same are contrary to the statements recorded and therefore cannot be held to be tenable. Punishment is also to be set aside. And my lord, in case lordship is inclined to allow the repetition, my lord, I would then refer to the judgment of this Honorable Supreme Court, my lord, in 2013, volume 10. 324, my lord, Dipali Gundu Survase, my lord. Dipali Gundu Survase versus Kanti Junior Adhyapak Mahavidyalaya. There, my lord, at paragraphs 38.5. Starts at 224, page 356.
What is the point? What is the point?
Supreme Court tries to say how to determine the back wages or other benefits that a person will be entitled to in case of disciplinary proceedings found to be illegal or not done in the proper manner. Their lordship may like page 357, para 38.5. The cases in which the competent court or tribunal finds that the employer has acted in gross violation of the statutory provision and or the principles of natural justice or is guilty of victimizing the employer or workman, then the court and tribunal concerned will be fully justified in directing payment of full back wages. In such cases, Superior Court should not exercise power under Article 226 or 136 of the Constitution and interfere with the award passed by the Labour Court merely because there is a possibility of forming a different opinion on the entitlement of the employer or workman to get full back wages or the employer's obligation to pay the same. Courts must always keep in view that in cases of wrongful or illegal termination, the wrongdoer is the employer and the sufferer is the employee workman, and there is no justification to give a premium to the employer for his wrongdoing by relieving him of the burden to pay to the employee workman his dues in the form of full back wages. Then under 38.6, in the number of cases, Superior Courts have interfered with the award of the primary adjudicative authority, and the premise finalization of litigation has taken a long time, ignoring that in majority of cases the parties are not responsible for such delay. Lack of infrastructure and manpower is the principal cause of delay for the disposal of cases. For these, litigants cannot be blamed and penalized if the amount of great injustice to an employer or workman if it is made back to simply because there is long lapse of time between the termination of the service and penalty given to the order of reinstatement. We should bear in mind that it is in most of these cases, employer is at an advantageous position vis-a-vis the employer or workman. He can avail the services of best legal ring for prolonging the agony of the sufferer. That is the employer or workman who can ill afford the luxury of spending money on a lawyer with certain amount of fame. Therefore, in such cases, it will be prudent to adopt the course suggested in Hindustan Inwards and Smith. Here, my lord, I'll also draw lordship's attention to page 356, para 38.3. The last paragraph. Ordinarily, an employer.
Mr. Mazumdar, the court will have a response to this. I've seen this judgment. But before that, let me get her response and then we'll come to the relief part and what the court is proposing, we will.
Regarding my lord, Article 1 is regarding his my lord, incident on that day, my lord, and Article 2 is then page number 25, my lord. Force number so and so Gautam Tala water sector CSF unit was given full.
No, we have seen everything. Please come to the main points now. There is no point going through whole
Yes,
thing
ma'am.
again.
Then my lord,
There is no evidence to prove that the petitioner was in a state of intoxication on 16th of March.
yes, ma'am.
He might have odors of alcohol coming out from his mouth. He might even be chewing betel nut.
Yes.
But chewing of betel nut is not the charge. As far as alcohol is concerned, he said that I consumed alcohol last night and therefore I might be smelling. But nobody has found that he was abnormal, his behavior was abnormal, or there is no urine or blood test, nothing. Some machine bulb,
Knowing
red
this.
bulb glowing and you throw it somewhere out of service, difficult to accept. You can be precise and the charge is not proved. That's what the court feels.
Only one witness said that he is supposed, my lord, that is Yadav.
So
assistant
it is
commandant.
it's preponderance of probability. 9 out of 9, 8 says nothing abnormal,
My
1
lord,
says abnormal.
51, my lord, page 51, another witness, that witness number.
So you know what is preponderance of probability? Which side it is heavier? So when out of 9, 7 says nothing abnormal, 2 says abnormal, which side is heavier? Which side? Preponderance is in which side? What to do?
My lord, my submission is that considering all this, my lord, revision petition has been considered and his punishment has been reduced to that, my lord, compulsory retirement, my lord. That is, my lord, and also considering his earlier behavior, my lord, and several times, my lord, in other occasion also, he was caught in that intoxicated position, my lord, from the search sheet, he appears from the search sheet, my lord. So, my lord, considering all this, my lord, that considering the justice, my lord, that 134 page number,
Justice was done to him by sending him to-
compulsory retirement from the service, my lord, and page 26, my lord, kindly see intoxication. Page 26 also, my lord. Number 1, search while intoxicated, folded with the scooter near BDO, so and so 812 at around 15:30. Then number 2, while detailed on internal security duty at ARCC Dumduma on 7/10/2000 from 18 hours to 6 hours. He was not found on duty and was found in the.
No, Miss Gayansi, if the charge 1 is not proved, charge 2 automatically falls.
Yes, ma'am.
Charge 2 is the repeat offense of earlier offense.
Yes.
But if the offense or the, not offense here, the misconduct is not proved, where is the question of repeating it? Is it now? You tell me what is the basis for the learned inquiry officer to arrive at a conclusion that he was in a state of intoxication? That's all I'm asking you.
Yes. That is my conclusion for page number.
Page number?
Page number 58.
58. Yes.
It starts from 58.
Hmm.
The following facts that come to the light on consideration of the statement of the prosecution and defense statement, study of the document, study of the question answers, my lord. My lord, kindly conclusion part, it is too long, my lord, 65, my lord. It is apparent from the circumstantial evidence statement of the force member so and so Gautam Talukdar headquarters arrived at CISF unit all division 15/3/2010 at 16:30 hours on regular posting from CISF unit IOC Guwahati and got his reporting recorded in control room at 16/3/2010 at 9:40 hours by General Diary entry number 548. On the same day, that is 16/3/2010 at 11 hours, Head Constable Driver Gautam Talukder was taken by PW3 to the Assistant Commandant. On presenting, Head Constable Driver Gautam Talukder was found in the state of intoxication of the alcohol and he had consumed alcohol, sent to the Oil Hospital for medical examination, which is proved by the witness number PW 1236789 in their statement. An accused force member has also admitted the same in his statement. In his defense, Head Constable Driver Gautam Talukder was examined by the doctor of Oil Hospital for consumption of alcohol. After examination, Head Constable Gautam Talukder was found drunk, which is proved by the evidence of PW2 and report of the doctor, which was exhibited as exhibit PW1EX3. And the accused Head Constable Driver Gautam Talukder had also clearly admitted in his defense statement that you are drunk, which is the fact. Therefore, it is totally clear that on 16/3/2010, Head Constable Driver Gautam Talukder had consumed alcohol, and when he was presented before the Assistant Commandant, and he had consumed alcohol and intoxicated by the alcohol. That is the conclusion of the inquiry officer matter. And before that, that is from case number, consider what consideration he has taken into account, that is 58 to 66, my lord.
But we find there is evidence only that much to show that there was order coming out. He was chewing betel nut. He was taken to the hospital. After that, there is no legally acceptable evidence of anything. What is this machine? Red bulb, green bulb? We don't understand what is this. What is the name of that machine? How does it work? Nobody has testified anything. So is it a Diwali device or what? We don't know. Was it a breath analyzer?
But my lord, he himself admitted, my lord, it's a breath analysis in his statement, Gautam Talukder, my lord.
So red bulb means what? What was when do you get a red bulb? What is the content of alcohol?
Content of alcohol is not.
There's
In
nothing
question
in that.
number 4, my lord, do you admit the doctor said that you were drunk when the red bulb, after the red bulb flash, the doctor herself said, I was drunk. My lord, he admitted.
She said that I was drunk. I never said I was.
And he also said that in
All right,
his.
now, Mr. Majumdar, even if you succeed,
My lord.
your readmission will be subject to your fitness to function as a driver.
My lord, that is what I was, my lord, also proposing at one point of time. I had tried to discuss with them. There are punishments galore on him. One cannot guarantee that he will not, or either he makes a mistake or the department takes it upon themselves to find out a mistake. He may again go home without anything. No matter if he is taken to be in service for the period till at least today. Now he has reached the period where on 20 years of service, he can go for retirement with all pensionary benefits that would have accrued to him. The pension would be a formidable amount which he can survive with the family. Only difficulty would be the time that he did not work. That time he has also spent in the official quarters, for which high recovery will have to be made because it is government money. Now, my lord, in case
He is still in quarter.
yes, my lord, they have cut off the electricity, they have cut off the gas. There is no water supply to his particular room that he's staying in with his family and his aged mother-in-law. His mother and father have expired. His mother-in-law, he's staying there, who is now suffering from cancer and is trying to treat her. He's also suffering from tuberculosis. So, my lord, if lordship feels it to be justified, if it is taken to be a continuity in service, he gets some monetary benefit out of it, and his retirement is counted from even today. His pension stays, they will not have a problem of keeping a problematic man in the force, and I would have the monetary balance to pay what I have to pay to the department because of use of the electricity, light, and the building itself. There will be some penal rent, of course. Minus that, if I'm given what I was supposed to earn for the period and the routine pension, well, I have talked to the client. We can have it there. There will be no difficulty on the department. There will be no difficulty on my part.
So if the order is set aside,
My lord.
Then you joined service in 97.
97.
So you have attained the age of retirement.
My lord, 97 to, I get in 20 years of service, I get full pension. I have got the option of going for a voluntary retirement. So 20 years would, my lord, that will be 2017. I have crossed 5 more years if I am continuing in service. So I can go peacefully on retirement. I will be getting all the
Voluntary
benefits.
retirement.
My lord.
Voluntary
That
retirement.
would be a sort of a voluntary retirement. Under 48, CCS rule 48, I can apply for.
And you will vacate the house.
My lord, yes, once they give me the payment, they cut off the money that they had to, as a penal rent or whatever dues are to them. Let them take it, let them give me the other part of the money, let them give me my gratuity, whatever they want to give me, my pension, take the money, I go. That would not put trouble to them, that would not put me to trouble.
But you can't claim back wages.
My lord,
It will be notionally computed for your.
if the back wages are not given,
Hmm.
then the whatever money I am supposed to get, everything will be recovered in the rent part. I will not get a single penny till today. Nothing comes to me. And I am in debt, my lord. 12 years when a man fights in the court, my lordship, I had given another judgment. If lordship will kindly have a look at the judgment, my lord, it was by this honorable court.
Hmm.
Lordship will like paragraph 17 of the judgment, my lord.
What do you have to say on this, Ms. Gahan?
Yes, I'm agree with that, but I have to take instruction from the whether they are ready to.
You
give
call the
the-
commandant,
Yes,
let him come on Tuesday, let him come here. You tell him that the court has requested you to be present.
yes, Tuesday night.
What we can do is, you see, instead of going for further complications now,
Yes,
because the court is convinced the charge is not proved.
yes,
Now, what he is saying, but then again, we didn't want to ask him to be reinstated. Because already how many, 13 years?
13 years gone.
He is now 52
And we,
years.
and he has tuberculosis, it will create a problem. He,
He is
Still to be
having
cured, but-
tuberculosis, he has a family, his
mother-in-law.
mother-in-law is a cancer patient, whatever.
If lordship would like to paragraph 17 of the judgment, my lord, there was some relief given by this honorable court in a circumstance like this, although there was a reinstatement. But what the honorable court had done is that remand back is not an issue now. We a lump sum compensation of 2 lakhs was given because he was given the reinstatement in service for the entire period from 1997 to 2018 when the matter was disposed of, since he was being given back his services.
And what is the rent for the house?
Malad, that penal, they will calculate a penal rent.
What is the penal rent?
Malad has, it's for 12 years, Malad, they have to calculate it out. It will be some few lakhs.
And you are occupying that house on the basis of court order?
No, my lord,
That,
because I could not shift out. It is penal rent, my lord. I am liable to pay penal rent. I am not arguing on that, my lord. It is the dues to the government. I will not fight on that. He has occupied it unauthorized.
see, you have to tell your clients also that the court is taking a balanced view in the matter. They should not be overboard also. Otherwise, you see, if you are convinced that charge is not proved, you have to reinstate and give him everything. You will be in service.
Yes,
You will come again chewing betel nut. And maybe something else. Unless you want to see that thing,
yes.
what we can do is through our orders, we can make provisions for that. So what the auditor will say, don't you tell your client not to worry. But then we have to get their views. If you can ask someone, this is from where? CISF?
It's Dulia's and
Dulia's.
No, but they have their office here also.
Here also.
Yes.
Yes,
Ask someone to be present.
yes, madam.
Can we have it tomorrow then?
Tomorrow I have difficulty Monday, my lord. Tomorrow I will be
Monday.
able to. my lord. Monday
Alright.
we can, my lord.
We'll have it Monday and
Yes,
then
madam.
pass the judgment.
Yes, madam.
Because
Law officer is here, my lord, from, law officer is
then
sitting
ask him to
here.
be present.
Yes, madam.
We would like to know what their view is. The order I am proposing to pass is that, of course, whether they agree or not, I'm setting aside the order of compulsory retirement. Option is either a reinstatement, full back wages, and he continues in service till his age of
Yes,
retirement.
madam.
Or other thing is setting aside the order, but no order of reinstatement. Instead, we'll record his submission that he will
Voluntary retirement.
apply for voluntary retirement. And we'll go for that. And he'll be given back wages minus the penal rate of penalty for the quarter in case he will not get it also. In that case, he will not get it. Where will you recover this from? So
I'll convey this, my lord, and let him in presence of that officer.
yes,
my lord,
that's
yes,
right.
madam.
That's why we don't want you to be in the middle of things, so. No, as a council, it's all right, but let the law officer, any officer
Any
come.
officer on Tuesday.
Come with the record. Come prepared with the instructions.
Yes, my lord.
Had Mr. R. Majumdar, learned counsel, appearing with the petitioner, also had Miss A. Gayan, learned CGC appearing for the respondents. Let this matter be listed again on Tuesday, give Tuesday,
Tuesday.
not Monday. Tuesday, that is so and so, as a fixed part-heard matter, as item number 1 of the hearing list, as the first item of the hearing list.
I'm obliged.
That's the best.
Item 17.
Yes. It is this way to call Govinda. What is this dismissal from service?
Dismissal from.
How long will it take?
My lord, on the last occasion, so records were called for them.
My lord, your lordship may please to consider the issue of jurisdiction. No part of cause of action arose within the jurisdiction of this honorable court.
That was not raised in the affidavit also. The first
The
time.
cause of action arose in the state of MP, my lord.
For
Then
the-
why it has filed here?
For the first time, my lord, they have raised today. Otherwise, my lord,
Today only first time.
yes, my lord. I have heard.
Why have you filed it in Guwahati?
He's residing, my lord, within state of Assam, my lord. The petitioner. will. Dismissal from service, my lord, without any inquiry, my lord, without any proceeding.
No, but jurisdiction will not entertain. This is Union of India.
Union of
Uh,
India,
Union of India is everywhere.
my lord, in similar circumstances, honorable Supreme Court says that mere resident of a person has not attacked the jurisdiction of the
No, that is for a person. You are not a person.
No, my lord, personnel, my lord,
Eh?
personnel, my lord.
This is the Union of India. Central government has nothing to
Central
do
government-
in Assam.
My lord.
They have no presence in Assam, you are trying to say.
My lord, it will take time, my lord. I will satisfy the court
Yes, yes.
that with regard to the jurisdiction.
We are hearing it today. Yes, yes. You try. You try, if you have luck, maybe something may happen, but difficult.
My lord,
Somebody is dismissed from service, Union of India is the respondent, what jurisdiction? We'll see if the person has been dealt with in accordance with law.
my lord,
Otherwise, we'll affirm the rule of law, as simple as that.
the Supreme Court.
This is not a contract between two companies or entities, which has one has office in MP, another has office, not like the Union of India is everywhere.
Supreme Court.
What,
similar
which Supreme, show
situation.
me the judgment.
My lord,
Supreme Court, you show me which Supreme Court judgment.
my lord, today.
No, Mr. Datta, this practice
let-
I don't appreciate. A matter is taken up for final hearing. It is only 3:20 now and you raise an objection and say some other day I'll argue. What is this in the High Court? You can't do it like this. You expect us to let him proceed. Yes. Yes.
My lord, the matter released to my lord dismissal from service, my lord, without holding any inquiry, without any proceeding, my lord.
Hmm.
The facts of the case, my lord, the petitioner, my lord, was a constable, my lord, general duty under CRPF. He joined on, my lord, 28/2/2003, my lord,
Hmm.
and he was posted after training, my lord, he was posted at different, my lord, station.
Let us see the list of dates first. On 28th of February 2003, he joined
Yes, my lord,
as constable.
my lord, constable,
General
general duty
duty.
under CRPF. my lord.
All right.
And after successful completion of training, my lord, he was posted at 35 Battalion, my lord, Srinagar. And 2000, my lord, one battalion was, my lord, constituted, that is, my lord, Cobra Battalion under CRPF, my lord. And the petitioner was included in that battalion, my lord. And training was
My lord, the petitioner also deputed for undergoing training, specialized training, my lord. On 28/3/2009, my lord, the petitioner was along with the other, my lord, constables were allowed to, my lord, go for local market. And on that day, my lord, when he was reported, my lord, for checkup, my lord, UIIC,
Again liquor, this is also liquor.
my lord,
This is also consumption of liquor.
yes, consumption, alleged consumption of liquor, my lord.
So there was no inquiry held.
No, my lord,
Where is the order?
that lordship will find that page 15.
Hmm.
1/5, my lord. Yes.
Who has passed this order of dismissal?
My lord, this is my lord commander. Commandant 204 Battalion, page 19, my lord.
Let me see the constitution, please.
Three hundred 2B, proviso B.
300
11,
and
2, proviso B.
So who was the appointing authority of the,
My lord, commandant.
and he was also authorized to dismiss?
Yes, as per rule. CRP approved 1959.
So they have, what is wrong in this? Why you say
Yeah.
this power could not have been invoked?
Yes, my lord, my lord, proviso 2B, my lord, of Article 311, my lord. It says that where the authority empowered to dismiss or remove a person or to reduce him in rank is satisfied that for some reason to be recorded in depth by that authority in writing is not reasonably practicable to hold such in faith. So my lord, the reason must be recorded, my lord. And that's my lord, the lord to be filed in order of include my
That
lord.
has been recorded, some
My
reason
lord,
has been recorded.
but I am, my lord, coming to that for my lord. At page 16, my lord. Plus 4, my lord. What is
Yes,
their reason, my lord? Whereas in a situations where disciplined persons indulge in acts of serious indiscipline, that too, to the extent of assaulting the officers, spreading stones, ransacking the office and residence of the officers, etc. As a mob, there is a possibility. The word used here is possibility of the personnel not coming out with clear statement of evidence as complicity is collective in the entire incident. There is possibility of personnel threatening each other not to depose also. Therefore, it is not reasonably practicable to conduct a departmental inquiry against the culprits involved in a serious acts of indiscipline and other criminal acts. At the same time, the continued presence of hooligans and discipline breachers is contaminating the discipline of the force, and it may give rise to mutiny if immediate actions is not taken to control the situation forthwith. Constable C.R. Kolita has already threatened that he could commit suicide if any actions is taken against him, and there is every likelihood that disgruntled people would go to any extent to damage the discipline and good image of the force. The situations is on the whole explosive, and any delay in actions may take more volatile and explosive. My lord, here the reasons, my lord, they have shown is, my lord, based on only on, my lord, presumption, surmise and conjectures, my lord. They, my lord, not supported any.
so do you have any authority on how this discretion under 311 to B is to be exercised?
Yes, my lord, that the, my lord, Tulsi Ram's Patel case, my lord. It has been allowed.
Just 1 minute, Mr. Sharma. What has happened to the other three persons? What is the decision you are?
Lordship, this decision is my lord, 1985 3 SCC
Hmm,
398.
Para number?
Para number, you will find, para 61, page 453. Sixty-one, 62.
So which is the summing up paragraph
Yes,
here?
para 62, my lord. Here the first consideration, my lord, regarding.
What is the law in this? How it is to be applied?
Yes, my lord, as provided in my lord, para 62, my lord.
Hmm.
The first consideration is, my lord, the conduct of the government servant to justify the imposition of penalty of, my lord, dismissal, removal, and, my lord, reduction from service, my lord. And in the present case, my lord, the conduct is, my lord, of the petitioner is not to such extent that he is, my lord, penalty.
So
of-
he reacted when he was asked to go for a
No,
alcohol
that,
test.
that is not true, my lord, because on that day, my lord, when, my lord, the sacral was, my lord, conducted, my lord, the, my lord, 2IIC of the, my lord, battalion, my lord, he asked for, my lord, medical, my lord, checkup, and which, my lord, I refused. And then, my lord, he become furious, and, my lord, he started beating me, my lord. And, my lord, I sustained injury, my lord. I was hospitalized, my lord. And in hospitals, my lord, I have also documents, my lord, regarding I was discharged on the next day, my lord. And the, my lord, even if any such incident took place, my lord, as alleged in the, my lord, impugned order, they ought to have, my lord, lodged an affair before the local police, my lord. That is not, my lord, they have done it. My lord, to safeguard their, my lord, own mistakes, my lord, they have, my lord, make a new story, my lord, and they impose that penalty, my lord. And, my lord, this, my lord, judgment at paragraph, my lord, 134 clearly says that when the, my lord, recording of the reasons is required to be, my lord, reduced into writing, my lord. That lordship, page 505.
Hmm.
May I read, my lord?
So supposing we say that this decision to dispense with an inquiry is bad, then what happens? What is the consequence then?
Well, since, my lord, the, my lord, consequential order of dismissal is, my lord,
Hmm.
is bad, my lord, then, my lord, I will have to be reinstated, my lord.
And that's all. Have you preferred any appeal or
Yes,
revision?
yes, my lord, that lordship will find. I have preferred appeal, my lord. I have taken all the grounds that lordship will find page 20.
Hmm.
And, my lord, the,
Page 20.
my lord.
Hmm.
I have
Appeal has
taken-
been rejected.
Yes, my lord, that lordship will find. Rejection order is also important because that lordship will find page 29.
And have you preferred any revision?
No, my lord. And the lordship will find page 30, the findings of the appellate authority, my lord.
Hmm.
Last second paragraph, my lord.
Page?
Page 30, 30, my lord.
Second paragraph from my lord, bottom. Agreed by the said order, Constable G.D. Ruben Kolita preferred an appeal against the same in the office of the undersigned. I have carefully gone through the said appeal petition documents and evidence adduced by the witness in connection with the said incident. My lord, wherefrom they have collected the evidence, my lord? Mechanically, my lord. And where is the medical document? That, my lord, I have, they leave, my lord, medical document, only my lord, discharge letter is there. That he was discharged on 24/8/9 and he was admitted on 23/8/9. That statement, my lord, I have made in the, my lord, appeal also. This is which hospital? Sivapuri Civil Hospital, Jilla Chikitsalaya, Sivapuri, MP. In the top, my lord. In the, my lord, so there were three other persons who were given the same treatment. What has happened? They have preferred any appeal revision. Are you aware what has happened to them?
To my information, they have not approached the associate court.
They have not approached the
Yes.
court.
To my information.
All right, now, Mr. Dattu, what have we got to say? According to him,
My lord,
this is not a fit case for dispensing with inquiry. The reasons are not sufficient.
my lord, besides the Article 311, my lord, the authorities are empowered by the rules.
Empowered.
My lord, I have rules, PRPF rules. Yes.
They are empowered, but the reasons must be, the reasons recorded must be.
They stated the circumstances under which they cannot hold the.
That's I find is wrong. Sometimes there are circumstances where it is not possible to hold an inquiry. Supposing an incident happened in a remote area where the witnesses are all unknown, nobody knows who's where, what is where. There, the charge cannot be proved. So that could be one of the reasons why inquiry is not possible. But this incident happened inside the camp. There were people everywhere. The charge could have been easily proved.
Mainly the appellate order, it is stated that they had some conflict with the public, my lord. And they were, police has helped them and informed the authority, my lord, in such arguments and conflict, my lord. Some injuries happen.
Have you understood the case, Mr. Datta? Have you understood the query?
Yes, my
The
lord.
reason given is found to be untenable. We don't want to know what happened. Nobody wants to know that. If your officers don't want to know, why should we know? Inquiry is done for what purpose? To find out the fact.
Yes, my lord.
The authorities here did not want to find out the fact.
Yes.
All right, that power is there.
Yes.
But you have to record reasons why you don't want to find out facts. The reason recorded, according to me, is completely erroneous. Practicable means not practically possible to do it. Supposing an incident happened 50 years back. Today, if somebody asks you to hold an inquiry, that will be impracticable because you are not going to find evidence 50 years back. People who were witnesses, they may not be there. Records may not be there. This is one instance of impracticable. Or an incident happened where nobody except the victim knows, so no question of getting an evidence. But this is a case which happened inside the camp. So they could have been easily suspended from duty, charge memo served. Evidences could have been adduced to show what happened. And once the charge is proved, they could have been imposed some penalty. But this cannot be used when you can't prove the charge, so throw him out. That can't be the way. This is not this is an exception. And then even if their projection is, your projection is accepted. He said, if you force me to go for medical, I'll kill myself. Well, if he has done it, it's a criminal offense. Have you lodged an FIR? Why have you not lodged an FIR? Why should we not ask your officer to be proceeded against for abatement of criminal offense? If he knew that this has happened, why did he not lodge an FIR? Attempt to murder, attempt to suicide is a punishable offense.
Yes, my lord.
So I'm asking you, have you understood? Otherwise, the judgment will be delivered. You will not know what has happened.
But in my consideration, this conduct of a personnel in a discipline department.
Okay.
It is caused the
All right. I'm not able to accept your submission. Anything else you want to say?
nothing, my lord.
All right, then take your seat. Heard Mr. Harsh Sharma, counsel appearing for the writ petitioner. Also heard Mr. A.K. Datta, learned CGC appearing for the respondents. Full stop. This writ petition is directed against the order of dismissal from service dated
31/8/2009.
31/8/2009, as well as the subsequent order dated, which is the order appellate authority?
13/11/2009.
13/11/2009 of the appellate authority, refusing to interfere with the order of dismissal. First up, the facts of the case in a nutshell are that the writ petitioner herein had joined as a constable, bracket general duty, bracket close, under the CRPF on 28/2/2003. So stop. After successful completion of his training, the services of the petitioner was placed under the 35 Battalion of the CRPF. Full stop. In the year 2009, the Ministry of Home Affairs had raised 204 Cobra Battalion BN bracket CRPF bracket close for being deployed against the terrorists and Naxalites. First up, the petitioner's name was proposed for the said battalion, and accordingly, he was amongst the 200 CRPF personnel, and accordingly, his services were placed under the Cobra Battalion. Full stop. On 23/8/2009, the writ petitioner, along with on 23/8/2009, while the petitioner was posted at Shivpur in the state of Madhya Pradesh, he had gone to the market along with 200 other personnel of the camp. Full stop. It appears that there was a check roll call in the camp, and the second in command, that is the 2IC, 2 then I/C, Sri A.K. Bharti had alleged that the petitioner and his colleagues had consumed alcohol and they were asked to subject themselves to medical examination. Full stop. At that, the petitioner had raised protest, on account of which he was beaten up by the superior officers. Full stop. The above conduct of the superiors had infuriated the colleagues of the writ petitioner, and as many as 800 personnel placed in that unit had assembled and protested against the manhandling of the writ petitioner by the superiors. Full stop. So manhandling of the writ petitioner and his other colleagues by the superior. Full stop. Due to the above gathering, some commotion took place, which had also resulted into damage being caused to some properties. Full stop. According to the writ petitioner, on the next day, that is 24/8/2009, some officials of the CRPF had come to the camp to inquire about the incident, wherein the petitioner had suffered injuries and was sent to the district hospital of Shivpuri. Stop. A few days thereafter, that is on 31/8/2009, the petitioner was asked to go on duty at Gwalior. First stop. On reaching Gwalior, he was handed over the impugn office order dated 31/8/2009, issued by the respondent number 5, by means of which the petitioner and his 3 other colleagues had been dismissed from service on the ground that they had revolted against the superiors and incited their colleagues to rebellious behavior. Full stop. The petitioner had preferred an appeal before the appellate authority, which was also turned down by the order dated 13/9/2009. Full stop. The basic grievance, the petitioner's counsel has argued that the allegations brought against his client are all false and baseless, inasmuch as it was the superior officials who had misbehaved with the petitioner and his colleagues. Full stop. If the authorities would have held a regular inquiry, then the petitioner could have proved the said facts by adducing evidence. However, in order to avoid such a situation, the commandant, that is the respondent number 5, had arbitrarily invoked Article 311 (2) (b) of the Constitution of India and dismissed the petitioner without holding an inquiry. Full stop. According to Mr. R. Sharma, learned counsel for the petitioner, the reason recorded for dispensing with the holding of an inquiry is wholly untenable in the eye of law and does not demonstrate as to why it would not have been practicable for the authorities to hold an inquiry. Full stop. By relying upon and referring to the decision of the Supreme Court rendered in the case of Union of India versus Tulsiram Patel, reported in 1985 3 SCC 398, Mr. Sharma submits that the impugned order is not supported by proper reason for dispensing with holding of an inquiry, and therefore the same is liable to be set aside by this court. Full stop. Mr. A.K. Datta, learned CGC, appearing for the respondent on the first count, has raised plea of maintainability of the writ petition on the ground of want of territorial jurisdiction. He also submits that the misconduct on the part of the petitioner was of such a degree that there was no possibility for holding an inquiry in this case. Full stop. As such, the impugned order has been passed without serving any charge memo or holding a regular disciplinary inquiry against the petitioner. Full stop. I have considered the submissions advanced by learned counsel for both the parties and have also gone through the materials available on record. Full stop. At the very outset, this court proposes to deal with the question of maintainability of the writ petition raised by Mr. Datta. Full stop. Such plea is on account of the fact that the incident took place in the state of Madhya Pradesh, but the writ petition has been filed in Guwahati. Full stop. What is to be noted here in that the main respondents, what is to be noted here in that the respondents in this case are the Union of India and the officials who have presence all across the country, including Guwahati. Moreover, the writ petition has already been admitted for final hearing. Full stop. The respondents have never raised the plea of maintainability of the writ petition at any stage. As such, I am not inclined to entertain the plea on the question of maintainability of the writ petition at this point of time. Full stop. Insofar as the challenge to the impugned order is concerned, I find that in the order dated 31/8 31-8 is the order.
Yes.
31-8, 2009. It has been projected that on being asked to subject himself to a medical test by the 2IC, Sri A.K. Bharati, the writ petitioner had threatened to commit suicide and had also tied a telephone wire around his neck. In full view of the personnel who were present for the check roll call assembly of the force, numbering about 600. On observing the same, some of the personnels, including Constable SI UP Singh, had rushed to save the petitioner for committing suicide. Full stop. It was also alleged that soon after the petitioner was saved, he, along with some of his colleagues, had incited the police personnel of the unit, which had created a revolt-like situation. Full stop. As a result of such conduct of the petitioner, the constabulary in general had become unruly and had turned berserk, BER, and had gone berserk, BER, SERK, and ransacked the office as well as the resident of the 2IC AK Bharti. The officers had to leave the area to save their lives and to avoid greater violence. While some other officers, such as Sri Akhilesh Kumar, DC, was trying to pacify the crowd, he had sustained head injuries due to pelting of stone. First of all. After recounting such facts, which allegedly pertains to the occurrence, the respondent number 5 had made the following observations in paragraphs 4, 5, and 6, which are reproduced herein below. Page 16, double tick, to page 18, double tick, full stop. Next paragraph. Article 311 of the Constitution provides that no person who is a member of civil service of the Union of India or an All India service or a civil service of a state or holds a civil post under the Union or a state shall be dismissed or removed by an authority subordinate to that by which he was appointed, except after conducting an inquiry in which he has been informed of the charges brought against him and is given reasonable opportunity of being heard in respect of those charged. Full stop. Proviso to clause 2 bracket of Article 311. However, contains an exception clause which permits the authorities to impose an order of penalty of dismissal, removal or reduction in rank of such person without holding an inquiry. Full stop. Clause B of the proviso to sub-article 2 of Article 311 would be relevant in this case and therefore is quoted herein below. It is clause B to First up. A plain reading of the impugned order dated 31/8/2009 also goes to show that the reason for not holding an inquiry is on account of the fact that it was not reasonably practicable to hold such an inquiry. Full stop. However, on a careful reading of the materials available on record, I do not find any basis for the above reason. Full stop. First of all, the incident evidently occurred inside the CRPF battalion camp and in presence of a large number of personnel, including the superior officers. Full stop. There are allegedly incidents of rampage and injury caused to number of officials, leading them to be admitted in the hospitals. Full stop. Under the circumstances, there were ample evidence available for the authorities to prove the allegations brought against the petitioners. Full stop. That apart, if it is really a case where the petitioner was trying to commit suicide, then also it is not clear as to why the authorities had not lodged any FIR with the police station. Full stop. Notwithstanding all such possibilities, the respondent number 5 has observed that it was not possible to hold an inquiry in the facts of this case. Full stop. In my opinion, such a conclusion was wholly erroneous. Full stop. Next para. It is to be noted herein that holding of a disciplinary inquiry based on charges being clearly known to the government servant is the requirement of the Constitution, and departure therefrom, if any, as per proviso to the Article 311(2) would only be permissible if the facts and circumstances are there to justify such a departure. Full stop. The proviso cannot be invoked merely to prevent the truth from coming to light by avoiding an inquiry. Full stop. Such a recourse, in the opinion of this court, would be violative of the constitutional right of the official. Full stop. Having regard to the materials available on record, this court is of the considered opinion that there was no justifiable ground for the authorities not to hold an inquiry in case of the petitioner before imposing a major penalty of dismissal from service upon him. Full stop. On the contrary, this court is of the opinion that by taking recourse to the taking recourse to the proviso to Article 311(2) of the Constitution, the respondents have denied a fair opportunity to the petitioner to defend his interest in the matter. First of, in view of the above, the impugn order dated so and so is hereby set aside. The respondents are directed to reinstate the petitioner within 4 weeks from the date of receipt of a certified copy of this order. Upon such reinstatement, it will be open for the authorities to initiate fresh disciplinary proceeding against the petitioner after serving him with a charge memo, if so advised. Writ petition stands allowed. I may do some cosmetic changes here because there is no time. 3 minutes to go. So I may make, but this will be the basic structure. Yes. Mm.
Removal, my lord. Removal.
Start. When will you finish? 2 minutes. You can finish in 2 minutes. No. No. Mr. Sai,
19 is a very short matter, my lord.
19 is a short matter.
Very short matter.
What is it?
I am for the responding, my lord. What is it?
What
They
is
want
it?
to, my lord, some.
My lord,
separate recommendation.
So, wait a minute, what is to be done in your case?
18 is not possible, my lord. Short date may be given 2013 matter.
Mm. Short date when? Tomorrow?
Anytime, my lord. I lost. I'm leaving to Ocean, my lord.
Please take it in the next week on a non-miscellaneous day. Yes, what is the short matter?
The short matter, my lord, the petitioner was serving in the ONGC, my lord.
Hmm.
He has retired from service, my lord. What happened, my lord, as per ONGC, there is a policy after retirement, the entire retirement benefit goes to the LIC, my lord. And the LIC gives monthly pension on the basis of the amount submitted before the LIC by the ONGC, my lord. There is another option, my lord. Some portion of the money can be taken at the time of retirement. But what happened, the petitioner was not aware of the entire facts, my lord. He has given the full 100% deposit to the LIC, and LIC is giving him pension 30,000 per month, my lord.
Hmm.
And there are now he is in need of money because his daughters and sons are going to all this family establishment requirements of money has come, my lord.
Hmm.
And now his unless it expires, money will not be given. That is the thing. So
So what is, you agree?
So far, ONC is concerned, my lord, ONC has given the money to LIC. We have no objection if LIC gives any amount to the my lord petitioner.
Who is for
Because
LIC?
LIC, my lord, they can give it, my lord.
So as the concrete, with that ONGC, LIC provided the monthly pension.
Because it is his money, my lord.
So what is the short matter here? He is not agreeing.
No, it is his amount, my lord.
Hmm.
He can, at his option, my lord, the LIC can give, my lord.
LIC can, but LIC doesn't want to.
Because we have no objection, my lord. ONC has no objection.
There is it is the matter of in between the employer.
LIC doesn't give money, LIC only takes. Why will he give?
No, that is his deposit, my lord, because ONC has transferred the entire amount to the LIC.
Hmm.
So from there, my lord, if any amount he wants 20%, that can be given by the LIC, my lord.
Yes, you are agreeable? All right. Heard Mr. B. Prakash, the learned counsel appearing for the petitioner. Also heard Mr. G.N. Saiwal and his senior counsel assisted by Ms.
No, no,
TJ Sahiwal.
he just.
TJ
G.N.
Sahiwal.
Saiwal appearing.
On behalf of respondent number, my lord, 2, 3, 4, 5,
This is says Hindustan
five.
Petroleum. Why are you saying ONGC?
my lord.
ONGC is a party here.
Yes,
yes,
ONC is the person, my lord. Because ONC has given the amount to the LIC as per it, my
Then
lord.
why is he implicated Hindustan Petroleum?
Where is
ONGC is not even a party here.
No, it is, my lord, there, your lordship is, two,
Uh-huh.
two,
Two.
two is the man, chairman come in to oil and natural gas corporation. 3 is my lord, trustee oil and natural gas corporation. 4 is also ONC.
Then I'm hearing some of the repetition. What is the WPC number?
913, my lord, 2018.
Oh, there's some other matter. Also heard Mr. J.N. Saivala, learned senior counsel, assisted by Ms. T.J. Saivala, learned counsel appearing for the
Expo number 2 to 5.
response numbers 2 to 5. Mr. D.P. Mondal, learned counsel is appearing, is present on behalf of response number 6. Huh? A.R. Mondal. Stop. The writ petitioner herein has retired from service on attaining the age of superannuation with effect on 28/2/2017. Full stop. After his retirement, the petitioner has given his consent to the ONGC to transfer the entire accumulated retirement benefits to a corpus fund held by the LICI, from which the petitioner is receiving monthly pension. Full stop. Mr. Purkasto submits that at the time of his retirement, it was optional for the petitioner to retain some amount, some lump sum, up to 1/3 of the total dues payable to him from the ONGC, and transfer the balance 2/3 amount to the LIC. But as the petitioner was unaware of the aforesaid scheme, he did not make a request to retain any amount. Full stop. Consequently, the entire amount was transferred to the ONGC. LICI. Full stop. At this stage, the petitioner has several family assignments, including the marriage of his children, and therefore is in need of some amount. Hence, the instant writ petition has been filed, seeking a writ of mandamus. Full stop. Mr. Saivala submits that the ONGC would have no objection if the money as permissible under the scheme is returned to the petitioner by the Life Insurance Corporation, represented by the respondent number 6. Full stop. Mr. Mondal also submits that if an application is made to that effect by the petitioner, the same will be considered and appropriate direction will be issued on that behalf. If that be so, nothing further survives for adjudication in this writ petition. With the consent of learned counsel for all the parties, this writ petition is hereby disposed of by granting 10 days time to the petitioner to make appropriate application before the LIC authorities by marking a copy to the respondent number 1 or 2. Respondent number 1.
No, it will be. Maybe 1 million.
Respondent number 1. Full stop. On receipt of such respondent number 2. On receipt of such application, the LIC authorities may process the same and take appropriate decision for release of up to 1/3 of the amount to the petitioner for his personal use by retaining the balance 2/3. Since Mr. Saivala has submitted that the ONGC would not have any objection if such a step is taken by the LIC, it would not be necessary for the LIC to seek any further NOC from the employer of the petitioner on that behalf. The exercise be completed as expeditiously as possible, but not later than 6 weeks from the date of receipt of the application. Writ petition stands disposed of.
Much obliged.
We have a case, date may can be fixed.
Why? You don't want to do it?
I will request her to fix.
You don't want to do it today.
I will request her to fix the date.
You take a date.
No,
Sorry, what? Yes.
But I can petition.
So you are.
Oh, yes, everything.
Obliged.